All right, we are on the record now. I'm a little rusty, so hopefully I'm using this thing correctly. All right, ladies and gentlemen, good morning. My name is Michael Davis, and I'm a county court judge here in Broward. I'm speaking this morning to everyone who's listening on the live streaming, but also in the jails at the main facility, North Broward facility, and the Conti facility. You're all here this morning, folks, because you've been arrested and you've been charged with a crime, a criminal offense. That offense is either a misdemeanor offense. Misdemeanor is any crime that's punishable by less than 1 year in jail, or a felony offense. A felony, very simply, is any crime that's punishable by more than 1 year in jail. Now, this morning is what's known as your first appearance. It's the first stop on the criminal justice system, okay? I'm going to explain to you a little bit about how the day is going to go, what some of your rights are, and then we'll move forward with everyone's individual case. First of all, everyone here who's been arrested this morning is innocent until proven guilty. You have the right to remain silent. This is a criminal matter. There's a state attorney here with me in the courtroom, and they are listening to everything that you're saying. And everything that you're saying is being recorded both on video and on audio. So today is not your trial. Today is not the day to talk about the facts of your case. Anything that you may say can and will be used against you, and again, it's all being recorded. The types of things that you may be encouraged by the public defender to talk about today are things like your community ties and your ability to pay a money bond, also known as bail, in order to get out of jail today and fight your case. Okay? You'll also have the right to an attorney. Now, if you can't afford to hire a private attorney, or you haven't had the opportunity yet to hire a private attorney, you have the right to be appointed the public defender. There is a public defender here with me in the courtroom live. There's also a public defender there in the main jail who is able to assist you today. And even if you think you're going to be hiring a private attorney going forward, the public defender will assist you for today's purposes, for today's hearing, if you wish them to. If you wish to represent yourself, that is certainly your right. You can speak with the public defender and let them know that. You also have the right to have your case heard by a jury of your peers. And after you see me today, your case will be assigned, if it hasn't been already, to a regular division judge, either one of the county court judges like myself or a felony judge in the circuit court. The case will move forward there, and you'll also have the opportunity to sign up with a permanent public defender. All right. Also, I just wanted to address before we move forward with the docket. I had done first appearances several years ago for about a year, and for everyone who's watching the live stream, I want to say that we appreciate, my office still gets many phone calls asking about us. The two big questions that we get is everything okay with Judge Davis? Why isn't he in first appearance? Everything is wonderful. I am now assigned to the South Satellite Courthouse. I invite anybody who wants to come down and see my docket to do so. Second biggest question we get is, do we still work with the youth? Yes, we do. We have amazing youth program down in South. We just welcomed a great mock trial program, and everything is wonderful. So please come down and visit me in South. We really appreciate all those phone calls and questions. Thank you so much for that. I'm going to call the cases. I have pulled to the officers in the jail. There's a few that I've pulled out of turn. We'll start with North Broward this morning. And I'll remind all the defendants this morning, I cannot answer any legal questions for you. I cannot give you any legal advice. I am acting as the judge only in this case. The person who can give you legal advice, however, is the public defender. So if you have questions of them, if you wish to speak with them privately and you didn't have the opportunity to do so before the docket started, please let me know and you'll have a few minutes to be able to consult with them. All right, let me go over to the North Broward Jail first, and I'm going to call Mr. Glenroy Haugat. Oh my goodness. Well, good morning. How are you, my friend? It's so nice to see you. I can't hear you though. I hope it's not.
I'm sorry.
Oh, there we go.
Sorry.
Well, you look wonderful. How's everything? How's your family? Everyone's good?
Everyone's good. Thanks for asking.
All right. It's been too long.
How are you?
Thank God. Everything is good. Thank you so much for asking. Please don't be a stranger. Call or come and visit me in South anytime. It's great to see you.
I will.
God bless you. Do you have Mr. Haugat over there?
So, Haugat?
Glenroy, Haughot. Oh, he's in the, I'm sorry. He's in the main jail. I'll be back to you. I'll be back in a minute. I'll be back.
Okay. All right.
Great to see you. All right, Mr. Haugott's in the main jail. All right, wonderful. Good morning. All right, hi there, Mr. Haugott. How are you?
Hudson? Thank you.
Wonderful. And good morning, Counsel. How are you? I'm Michael Davis. Great to meet you.
Well, thank you. You too, Judge.
Thank you. All right, Mr. Haugott, good morning, sir. You're charged with possession of MDMA, also known as ecstasy, and also possession of cannabis. That's a misdemeanor charge. I've read the probable cause affidavit. I am going to find probable cause for the charges. But now we can talk a little bit about this bond and what some of your connections are to the community. Let me speak to the state attorney's office first. Any priors, Mr. Linder?
Yes, Your Honor. Mr. Haga just got out of jail this past Monday after serving 72 days in county jail on a burglary of a conveyance.
Okay.
He also pled out a theft from late July of this year. Has an attempted robbery with a firearm or deadly weapon in 2016. Violated probation, received 364 days county jail. Nothing further, Judge.
Okay, all right, thank you. And whenever you're ready, let me hear from the public defender, please.
Yes, Judge. At this time, my client, due to his financial situation, meaning he does not have the ability to post bond, he's asking this court if the court would release him on his own recognizance.
All right. Sir, I'm not going to be able to do that today. I'm going to keep the bond at $1,000 on count one. There's no monetary bond on count two. And if you're not able to bond out, you'll see the division judge soon, all right? Best of luck to you.
Thank you.
All right. How are you doing? Just slide him down? Or? All right. I don't like this bench. It's so weird. All right. Let me go on. So now I'm going to call several cases that have charges with various cities, municipalities. We have a public defender here in the courtroom who contracts with those cities, and I'll call out the page numbers for the jail. So first, I'm going to start with Michael Downey. His case is on page 7.
Morning, Judge. Thank you.
Hey, good morning.
For the record, Stephen Plant for him.
Here's Mr. Oh, there he is. Hi there, Mr.
morning,
Downey.
sir.
How are you? All right, very good. Mr. Downey, you've been charged with a municipal ordinance violation. It's a trespass in the city of Hollywood. Now, I have Mr. Plant here. I don't know if you can see him, but he is a public defender that contracts with the city, and he's going to represent you today free of charge. That's at no cost to you. Now, let's see here. This charge either will go to the South Satellite Courthouse where you'll see Judge Coffin, and I'm happy to release you without a monetary bond today, or if this is a case that you want to work out, I can make an offer today if you want to resolve the case completely. And Mr. Plant was kind of shaking his head saying he thinks that you may want to work this out.
Well, no,
Oh, okay.
I didn't think.
We also have community court only for Fort Lauderdale cases. Then he would have to, it would be RR also.
Oh, is this a Fort Lauderdale case? Oh, I see. I thought it was Hollywood. I'm sorry. Yeah. Yeah.
I think it's Fort Lauderdale. So, but he would have to go to City Hall on Wednesday. And
Okay.
he would also have free, they provide services. It's Judge Barner.
Right.
It's entirely up to him. There's incentives for him. They give him a lot of free services. Those passes. It's entirely up to you. You could resolve your case today.
So, Mr. Downey, I don't mean to embarrass you, but I see on the sheet here it says that you don't have a permanent address. So if you are homeless, like Mr. Plant said, there is a community court that's available, and it's geared towards helping those that don't have a permanent residence. You just have to come down to Fort Lauderdale City Hall on is every Wednesday?
Yes, Your Honor.
Do you know what time?
It's 8:30.
8:30.
The address is 100. I don't know, he may know where it is, but it's 100 North Andrews. It's a block north of Flower Boulevard.
My friend Judge Barner presides over that court, and it's sort of geared towards helping with services. It's more of a helping court. If that's something you're interested in, you can absolutely, I can refer you to that court. I can resolve your case today, or I can release you on your recognizance, and this will go to a regular division. The only issue with that, I will tell you, is that in a regular division, they're going to set a court date for you. They're going to need an address where they can send you notice where to go for the next date.
I have an address where they could send it. Where I receive mail at.
Okay. So do you know what you'd like to do today? How you'd like to go forward?
I mean,
could resolve the time
Release,
served.
release RR and then send up to the division, how you just said.
Okay, so you don't want me to refer you to the community court?
No,
Okay, all right, so I will release you without a monetary bond. Now, we will need an address, the clerk will need an address where your mail can be sent, because if you don't show up to the regular court date, the judge will issue a warrant for you, okay?
I understand.
All right, either you can call here and give Mr. Plant that address, or if you're comfortable just saying it out loud, the clerk will write it down.
7584.
Go ahead,
As he started, right? On Garfield Street,
Garfield Street, 70, and that's
Hollywood.
Hollywood. Okay, got that, 7584 Garfield Street? All right, that's where they're gonna send the notice, sir, okay? You'll be released later today, okay?
All right, thank you.
You had another question? Oh, I'm sorry, do
Is
you
it
know? do you have-
33021, sir? 33021 is your zip? Your zip?
33024.
024. Okay, all right, very good. All right, good luck to you, sir. Zoltan
Good luck, sir.
Sabo.
He's also in Maine.
All right, great. Hi, Mr. Sabo, how are you?
Good morning. I'm fine, sir.
All right, so, sir, you're being held on 5 misdemeanor warrants. 1, 2, 3, 4 of them are municipal ordinances of the city of Hollywood. One of them is a state charge. They're trespassing charges, and one is carrying an open container of alcohol. So you actually, most of these charges are assigned to my friend Judge Coughlin, who's in the South Courthouse. She does have a diversion program that she offers down there, if that's something that you're interested in, going down to Hollywood. The other option, we can resolve these cases for you.
You can resolve it.
Okay, you want to resolve all these cases today? So
Yeah.
what I basically offer you on all the charges is a withhold of adjudication. No further time in jail. You'd be released today. Now, do you have any ability to pay any kind of court costs? Are you working right now, or?
No.
No.
Your Honor, no.
All right. Let's reduce the court cost down to a civil lien. So what that basically means is, if you ever do come into some kind of money, if you ever get a job, if you try to get some kind of credit, anything like that, it will just show that there's a court cost lien on your credit, okay?
Yes, Your Honor.
All right, Mr. Sabo. So you'll be released later today. Try to stay out of trouble, okay?
Good luck, sir.
Thank you, sir.
All right, good luck to you.
Roman, Darius, Roman?
Get up. Get up. What?
Oh, boy. Okay. Now on page 8, Christopher Floyd. Christopher Floyd? Oh, there he is. Okay, great. All right, good morning, Mr. Floyd. How are you? All right, I'm Judge Davis. Actually, your case, sir, is assigned to my division in the South Courthouse. You were charged with a municipal ordinance in the city of Pembroke Pines. The charge is soliciting panhandling, basically. So you would come see me anyway. If you want to work this case out today, Mr. Plant, I'd offer him withholding court costs. Is this a case you want to work out today? Okay. Do you have an ability to pay the court costs? There would be, I think it's $78. All right. So I'm going to reduce this to a civil lien, and what that means is if you ever come up to try to get credit or anything like that, it'll just show that you owe $78 in court costs. Okay. All right. Good luck to you today. You'll be released today, sir. Good luck.
Good luck, sir.
Seth Angelo.
Now next is going to be on page 10, Miguel Rivera. Okay, great.
I think I forgot one on the list of North Broward, but it's on page 1.
On page 1?
So we'll probably do it.
All right, we'll go back to it. Okay,
yeah,
I'm
we'll
sorry.
do it. It'll be the next one. Or the last
Perfect.
one anyway.
All right. Hi, Mr. Rivera. Thank you. Let's see here, sir. You're being held on a misdemeanor warrant. The charge is petty theft. So we can work this out today. If you don't have any prior arrests, you might be eligible for the state attorney's diversion program. But if you do have prior charges, they wouldn't let you into that. And if you want to resolve the case today, you can.
I'll resolve it.
You resolve it, okay, so
Who's
yeah,
this?
this is Mr. Rivera, Miguel Rivera?
If I just have 1 moment.
Sure,
One moment.
sure.
Add on.
I know, I'm looking for his paperwork though.
He can go also to community court if he chooses.
Oh,
I'm
okay,
not sure if he's gonna, I mean, he would get a warrant if he doesn't go.
right,
So-
right.
Steve, where is he?
It's an add-on of 10, bottom of 10.
Thanks. Oh, okay. No,
It's an
it's an MOE, because I know you mentioned the state's diversion program, so I thought there was a
City.
state charge.
I meant the city, I'm sorry,
Yeah, no,
I meant
I'm-
the city,
I didn't
sorry
mean to
about
hold
that.
you up.
Oh, thank you, thank
City
you.
for law, though.
Yeah, you know, it's okay.
Yeah.
There, as Mr. Plant said, there is the community court that is available to you if that's something that you want to avail yourself of. You'd have to go on Wednesday down to City Hall in Fort Lauderdale, and it's sort of a helping court. Judge Barner can offer services, things like that. But if you want to resolve the case today, I would offer you a withhold of adjudication and court costs.
I'll resolve it.
Okay, all right, very well. So it'll just be a withhold and court costs. It says $78 court costs, okay?
All right.
All right, very
Good luck,
well.
sir.
Give you 90 days to pay that. Good luck to you, sir. You'll be released later today.
All right, thank you.
All right, wonderful. Then on page 22, Nicholas Martinez.
It's also an add-on, it doesn't, I don't know where he's at. Nicholas Martinez.
He's actually got an out-of-state felony warrant. I was gonna, if he wants to, I was gonna resolve the MO.
Steve.
Ooh, okay.
Does anyone have Nicholas Martinez?
Someone's coming up there.
Someone is coming up there, yeah. All right, they may not have brought him, no,
Mr.
that's
Martinez?
That's not Mr. Martinez, I'm looking at the booking.
He may not have been
photo.
brought out yet.
He may
for
not be brought
security.
Yeah, oh, that call, he wasn't up.
Yeah, all right, let me put the case to the side. Steve, if you want to go, you can. When he comes up, I just give him a withholding court cost on this, because they got.
You need me to get him, Your Honor? He said
No,
I can grab it.
It's not an emergency. If you want to,
Okay.
Steve, you're okay with the withholding court cost later?
I don't, we have to see, I think the state's telling me this is a violation.
The
in another
booking
state.
indicates, Your Honor, his out-of-state hold is
We're
for
gonna
a
find out
violation of
what's gonna
probation.
happen.
Oh.
He may not, it's up to him,
Okay.
but it may affect.
It may affect that, yeah. Do you want me to have them bring him up, or you don't mind hanging around a little bit?
No.
Okay, all right, so let me put him aside when he comes up, I will, all right. All right, and we have a special prosecutor here, is it, statewide? Hi, how are you? Nice to see you.
On behalf of the Office of Statewide Prosecution.
Great, thank you for coming down, and let's see, so the case is on page 18, Lorenzo Parish. Let me just get down there. Ah, okay, great. Does he have private counsel that you know of, or?
Not that I'm aware
Not that you're aware of, okay, all right. Is Steve Parish, I'm sorry, Steve, Lorenzo Parish down yet? Possible he's not there yet. Lorenzo Parish?
Your Honor, he's coming. He was
Okay.
still-
Not a
he's
problem.
at-
No, all right, just give me a heads up when he gets there. Thank you so much.
You're welcome.
All right. All right, let me go then. Now we should be back in regular docket order, starting with Elda Marcel.
No problem.
Great. All right, good morning, ma'am. How are you?
Morning.
Let's see here. It looks like you're being held on a misdemeanor warrant. The charge is driving with a suspended license. Now, this is count 3 for Miss Marcel. Is she being held on other charges, Mr. Linder?
Yes, she is,
Your Honor.
Judge.
Now, technically, this was issued while she was in custody.
Okay.
So
Right.
if she wants, she is legally entitled to an ROR.
She'll lose
That-
it.
That being said, she's got a $50,000 bond for aggravated child abuse and a no bond hold for a probation violation of child abuse. So
Okay.
she's not going anywhere either way. So-
Right, and she'll lose her game time if I...
Exactly.
So, ma'am, basically, I'm happy to release you on this charge, but if I do that, you won't get any credit for time on the case. So you can, I don't know what the public defender would recommend. I can't make a recommendation, but,
I would not, and we talked about this, I would not recommend that you resolve it. I think the capias should be lifted, and not ask the court to set a minimal bond.
I'm fine with that. So I'll lift the warrant. I'll set up a $25 bond.
Thank you, Judge.
All right, ma'am, good luck to you.
Thank you.
Stephanie Jolly.
North Broward, and this is a municipal ordinance case.
Oh, yes, that's the one Steve was talking about. Okay, hi, Miss Jolly, how are you?
Good morning.
Good morning. All right, let's see here, ma'am. So we have Mr. Plant here representing you this morning. You're charged with a municipal ordinance violation. It's a trespassing. This is a Fort Lauderdale case. So what we can do, ma'am, if you want, you're eligible for the community court. It's a helping court here in Fort Lauderdale.
She wanted to resolve it.
How are you, sir? We're just talking about you.
Judge, I think Mr. Reedy we spoke with her, she wanted to resolve.
Yes, I would like to
You
resolve.
want to resolve the case today? Okay, so what I would do, ma'am, if you want, I would just withhold adjudication, and there'd be $78 court costs. Do you have the ability to
All
pay
right.
court costs right now?
Not right this minute, but if I could do the payment plan.
All right, let's give her 6 months to pay the court costs, okay? All right, good luck to you, and you'll be released today, okay?
All right, thank you,
All
sir.
right, take care of yourself.
Just so they brought up Mr. Rivera, I spoke with him.
Oh, good, Mr. Rivera,
I just
okay.
spoke with him.
You mean Mr. Martinez?
Martinez, sorry,
Martinez, okay,
yeah,
all right, Martinez.
Nicholas Martinez.
He's in main jail?
He is at main jail, yes,
Main
Your
jail,
Honor.
okay, so let me call
that's
him
what I
up,
was
that way I
talking
can chat here. Nicholas Martinez?
to. Nicholas Martinez, there he is.
Good morning, sir, how are you?
All right.
Good. So, sir, you're being held on a warrant. It's a charge of an open container of alcohol. Now, normally I would say I'll resolve that case for you. You are also being held on a felony warrant for another state. So I know Mr. Plant spoke with you. He's your attorney. He's representing you today free of charge. Do you know what he wants to do, Mr. Plant?
Judge, he indicated he wanted to resolve.
Okay.
This will not violate because it's a city,
Yeah.
it's a municipal ordinance that, his case is in another state, so we
Right.
can't really give advice on
Of course.
that state. But he told me he wanted to resolve, he doesn't have a recollection of 2017 where this matter happened.
Of course, of course. All right, I'm happy to resolve the case, and what I would do is, the offer would be a withhold of adjudication and the $78 court costs. The only thing is, I'm sure Mr. Plant already told you, I don't know, he doesn't know if this will have any effect on the charge in the other state, okay? Does that make sense?
Yeah, may I say something? Any,
Go ahead, yeah, you may, I just want you to remind you,
already
everything you're
spoke,
saying is
sir.
being recorded.
I get it, I get
If
that.
you resolve, they'll transport you to that state. If not, we
Yeah, any open containers that I've ever had, I've always done the time from, so I don't even know where this is
that's
coming
what this
from.
is, so we can resolve it.
You didn't pay him any money? So you don't have.
Well, like I said, I'm happy, if you want to resolve it today, I'm happy to just offer you a withhold of adjudication and the $78 court costs.
Yeah, cause that's only, it's a misdemeanor, it's not gonna bother my.
It's not even it's a
DOT.
city
Right, it's
violation.
a city violation. Okay, withholding court costs, all right. All right, sir, so you're all set, and it looks like you've got a status hearing set up on the out-of-state hold for October the 28th, okay?
So, okay, so I got another court date here?
Yes, what they'll do is,
Extradition court, right?
yeah, it'll be, yeah.
Judge Malika.
Judge Malika, yeah. They'll bring you down, and basically, she's gonna tell you your rights about being transported to Louisiana, okay?
Okay, so when is it, the 28th?
The 28th at 8:30 a.m., okay?
All right,
That's
all right,
latest.
thank you.
All right, good
Thank you,
luck to you,
Judge.
sir.
That's it.
God bless, take care,
Yeah,
Steve.
let's see too.
So nice to see you. Please send regards to the family. All right, back on the regular docket order, we've got Ashley Marie Kessler,
She's a medical research, Your Honor.
Meta Reset, okay, great. Brianna Mohorn.
No problem.
Okie dokie. All right, hi there, ma'am, good morning.
Hello, good morning.
You're being held on 2 warrants for, they're both traffic violations. The charges are operating without a valid license and permitting an unauthorized person to drive your vehicle. I'm going to give you 2 choices today. I'm more than happy to release you on your recognizance on these charges. It doesn't mean the case is over. You would still have to go to the next court date. It looks like this would be out in the West Satellite. I'm also happy to offer you, to resolve the cases today, it would be a withhold of adjudication and court costs. The only benefit to you to going to another court date is you might be eligible for the state's driver's initiative program, where if you get a license within a certain amount of time, they'll drop your case. Now, I don't know if this count 2 is a dip authorized case, right? It's not. All right, so I don't think you actually would be allowed to be in that program. So, as I said, the two choices are I can release you on your recognizance, or if you want to plead the cases out, I'd offer you a withhold of adjudication and court costs today.
Okay.
You want to do
Yeah,
that? You
Yeah,
wanna
Ms.
do-
Mahorn indicated to me earlier she would like to resolve these
You wanted to
matters if
resolve them.
possible.
Okay, all right, very well. So I would accept a plea of no contest. And, ma'am, here's what I'll do. The court costs are $293. What I'll do is, it'll be court costs only on count one. We're gonna waive the court costs on count two. I'll give you 6 months to pay that. Do you think you can do that?
Yeah, I can do it.
All right, good luck to you. You're gonna be released today. They'll give you the paperwork about the court costs, okay?
All right.
All right, God bless you. All right, take care of yourself. How about Valone St. Louis?
What's the first name?
Good morning, Miss St. Louis. Good morning, how are you?
Good morning.
All right, ma'am, you're being held on a warrant. The charge is petty theft. So I'm going to offer you also some choices today. If you have no priors, you could be eligible for the state's misdemeanor diversion program. I can't give that to you today. You'll go to your regular division judge. If you do have some prior arrests, charges, and or if you've ever done a diversion program before, you would not be eligible for that program. I could release you on your recognizance on this charge. You just go see your division judge. Or if this is a case that you're interested in working out today, I'd offer you a withhold of adjudication and court costs.
Thank you, Judge.
Sure.
What's going on here?
Judge, she'd be willing to accept the court's offer, please?
All right, very well. So it'll just be a withhold of adjudication, and the court costs are $293. Do you think you'd be able to pay that within 6 months?
6 months. Okay, that's enough time. Yeah.
If you need more time, that's okay. It has a year.
Can you please give me more time? Because, I have kids.
Sure.
And I'm a single mother.
How about a year to pay, okay?
Oh, yes.
Okay.
Perfect.
Thank you.
Let me ask the clerk, actually, because in South, I always let everyone make partial payments. Will they take a partial payment here, do you know? Okay, they'll do a payment plan. Okay, and they'll do a payment plan with you if you want to go and speak to the clerk's office. All right, fantastic. So you're all set. You know what? Stay up there for one moment because it's been a while since I've done first appearance, and I neglected in the beginning to explain to everyone, if you're charged today with a misdemeanor, and you want to work your case out, if I make you an offer to work your case out, what it is 99% of the time I'm offering a plea of what's called no contest, and I'm withholding adjudication. Those are very complicated legal terms. They're very confusing. This is what it means to your life. If you take a plea of no contest, it means you're saying, Judge, I'm not admitting that I did anything in this case, but I will not stand in the court's way of making a finding. And by me withholding adjudication, what shows on your record is that at some point you pled no contest to a misdemeanor offense. Now understand, if a background check is done for school, for a job, for the military, for law enforcement, it will show on the background check, and this applies to everyone, this is not just Miss St. Louis, this applies to everyone, it will show on the background check that at one time you pled no contest to a misdemeanor, and you may have to explain that to the school, the job, any other institution that's doing a background check. Now, this is extremely important. This is required by law of the state of Florida that I let everyone here know that if you are not a citizen of the United States, if you have an immigration issue, if you're applying for citizenship, taking a plea, even a plea of no contest where I withhold adjudication, will very likely have an effect on your immigration status. Understand, I am a state court judge. I'm not a federal judge. I don't work for ICE. I don't work for the federal government. I have nothing to do with their process. And no one here has contacted immigration. That's not our job. However, they are looking at these types of things, and so you must be aware of that. Speak with your public defender before accepting any kind of an offer. Finally, if you accept an offer of no contest, you're waiving your right to a trial, you're waiving your right to an attorney, although you have an attorney today, the public defender, that you can speak with before accepting any kind of an offer. All right, that's my very long-winded speech to everyone. Ms. St. Louis, Good luck to you. I hope everything works out, okay? And you have a year to pay. If you want to work out a payment plan with the clerk's office, they absolutely will do that, okay? All right, good luck to you. Take care. All right. I saw everybody come. Do you want me to call Mr. Guziano now? Are you ready to go? All right, fantastic. Let me call Ethan Guziano out of turn if they've brought him down. And he does have counsel here present in court.
Good morning, Judge. Thomas Durrell on behalf of Mr. Gunazzo.
Good morning. Nice to meet you. Thanks for coming.
Oh, you're welcome, Judge.
All right. All right, good morning, Mr. Gunazzo. I'm Judge Michael Davis. And you have your attorney here. You also have several family members that have been patiently waiting here this morning. I don't know if you can see them on the camera. They're standing next to your attorney. This is a very serious charge this morning, sir. It's a charge of premeditated murder. I've read the probable cause affidavit and the warrant. Any arguments as to probable cause?
The one argument or position I would have is I've had a chance, the prosecutor graciously gave me the warrant.
Good.
It would be my position that the facts alleged do not substantiate premeditated first-degree murder. I don't think that there's anything in the affidavit that was submitted by Broward Sheriff's Office to establish that, assuming Mr. Gunazzo went to the premises as alleged, that he went there with the premeditated intent to commit a crime, let alone the murder that's alleged in the affidavit.
Good. Let me hear from the state attorney, please.
Your Honor, first, as far as probable cause, Judge Murphy found probable cause when he issued the arrest warrant. Secondly, Your Honor, the state would be seeking a no bond hold upon a finding of proof evident or presumption great for first appearance purposes only. Your Honor, I would note the allegations are is that the defendant brought the firearm to the residence, one. Two, I would note there's no indication that there was a struggle and the firearm just accidentally went off. Witnesses said they heard 5 or 6 gunshots, Your Honor. Considering he brought it there, multiple gunshots, no sign of a struggle. I would argue for first appearance purposes that the evidence would indicate that this was a premeditated act. Even if the intent was formed moments before the shooting, as the court is aware, premeditation can be formed almost instantaneously.
All right, let me say this, and sir, your attorney has made a good argument. He's clearly an excellent attorney. Let me say this. For today's purposes, for the first appearance hearing, it's what's called a non-adversarial proceeding. I, as the judge, have to take every word of this affidavit to arrest, which has already been reviewed and signed by Judge Murphy, as true. Your attorney down the line is going to have a more fleshed out hearing as to whether or not this act, if it did occur, constitutes premeditation. But although your attorney has argued, and he's argued well for me to reduce the charge, for today's purposes, I am going to find probable cause. I will confirm Judge Murphy's finding of the charge of premeditated murder. Now, the state is asking me to hold you without bond. Per the Florida Constitution, I am allowed to do that. But I will allow your attorney to make an argument for bond, and the state attorney has already told me what they would like for me to do. So if there are bond arguments, and there will be an Arthur hearing, but let me.
Yes, Judge. It would be my position, Mr. Gunazzo is born and raised in the state of Florida. He has ties to the community. At the time of this alleged incident, he was gainfully employed. He obviously, his family cares enough about him to be present in court. If there is any evidence of a prior criminal history, it's minor drug-related offenses which occur after a traumatic automobile accident that our client sustained. He has no prior violent criminal history. I don't believe that he is a danger to the community. I would believe that a bond and or house arrest with an ankle monitor would be sufficient to protect the community in this case.
Very good. Let me hear from the state.
Your Honor, the state would be asking the court not to exercise discretion at this time and keep the no bond hold in place. Your Honor, I do consider Mr. Gunazzo to be a danger to the community. He stands before the court charged with a capital offense. The court has found proof evident or presumption great. I would note the strength of the evidence. 2 separate witnesses identified Mr. Gunazzo as the shooter in this case. Additionally, Your Honor, I do not see a significant criminal history. That being said, that is but one factor, and I think it is heavily outweighed by the severity of the offense, the potential consequences he faces if convicted of this offense.
Yeah. It's a very serious charge for a very young man, a 22-year-old young man, and I'm sad to see you and anyone in this position, sir. For today's purposes, however, I am going to hold you without bond. I'm going to find, only for the purposes of first appearance, that there is proof evident presumption great based on the warrant that's been presented to me, to hold you without a monetary bond at this time, being clear that you will have the opportunity very shortly to have what's called an Arthur hearing. I'm sorry, I'm having a senior moment there for a minute, where you will be able to, your attorney will be able to flesh out some further arguments to try and get you a bond released potentially on house arrest with a monetary bond. But for today's purposes, I will leave you in the custody of the Broward County Sheriff, and you will see your division judge very soon. I will note that the family members were the first ones here this morning. Clearly, they care very much about you, sir. That says something about your ties to the community, folks. I strongly encourage you to be at as many hearings as you can be. Thank you for caring about your child, and be in touch with Mr. Girella. He's an excellent attorney. Okay. Best of luck, and be in touch with your attorney, sir. Okay. Thank you, counsel. Thank you for coming in. All right. All right, back on the docket order, I'm going to call, oh, you know what, before I do that, we still have statewide here. Has Lorenzo Parish been brought down yet?
Yes, Judge, present.
Oh, wonderful, wonderful. Thank you so much. Good morning, Mr. Parish. How are you? Good morning. And we have the Office of Statewide Prosecution with us this morning. Good morning. Nice to see you. Sir, you've been charged with trafficking in heroin, possession with intent to sell, manufacture, or deliver heroin, and possession with intent to sell, manufacture, or deliver cannabis. I've reviewed the warrant that's been signed by Judge Siegel, I believe it was.
That's correct.
Who found probable cause, and I will continue that finding. Let me hear first from the Office of Statewide Prosecution as to bond. There have already been bonds set by Judge Siegel.
That is correct, Judge. The bond was set by Judge Siegel, as well as multiple special conditions including the area. Additionally, I filed the information yesterday on this case.
Okay.
So I would ask the court to just leave everything in place at this time, and any bond motions the defense may have at a future date, we can address with the trial judge.
All right, very good. Let me hear, please, from the Public Defender's Office.
Judge, if I may just have a brief moment, please?
Please, take your time.
Judge, I had the opportunity to speak with Mr. Parrish. At this time, a financial monetary bond will not work for Mr. Parrish. He has no access to money in a checking nor savings account.
Okay.
He has resided in Broward County his entire life. He does work with Sam Page Construction, as well as washing cars here locally in Broward County. He lives with his grandparents here again locally in Broward County. He also has 5 children that he supports. All 5 of these children live with him. That would be the reason why a financial bond would be difficult at this time.
Okay.
I am not familiar with his criminal history, so forgive me, I don't have that information in front of me. But I am asking the court if the court would consider pretrial release for Mr. Parrish in lieu of a monetary bond.
All right. And I sympathize with you, Mr. Parrish. Is there someone that's taking care of the children while you're in this situation? Their mom or a family member?
Well, one of my baby mothers died, and my other kids with my other baby mother.
Okay. All right. So they are with someone right now. There is an adult with the children.
Yeah, but
Good.
she's not secured like that.
I understand. No, I completely understand. At this time, I'm going to leave the conditions that Judge Siegel had put in place, including the monetary bonds. There's a passport surrender requirement, there's a NEBIA requirement, and you will have a hearing on that with your public defender, or if you choose to hire private counsel. But at this time, it'll be a $250,000 monetary bond on count 1, 5,000 on counts 2 and counts 3 respectively. Good luck to you, sir, and you will see the division judge soon, all right? Thank you, counsel, for coming in. I appreciate it. Have a wonderful day.
You do the same.
All right. Daryl Galasco. All right, good morning, how are you? Let's see here, you're charged with burglary of an unoccupied conveyance and trespassing. I'm gonna find probable cause for the offenses. Any criminal history?
Yes, Your Honor. There's a juvenile history.
All right,
I can advise
she's
the court
19.
it's
You
of.
want me to go off similar?
It's of similar nature.
Has she been evaluated by pretrial? No. Oh, you don't, they used to interview them in the jail first. Oh, not anymore, okay. All right. Let me hear from the public defender's office.
Judge, I did have an opportunity to speak with Ms. Glasgow here this morning. As you can see from the docket, she is 19 years of age. She does live with her grandmother. She has lived in Broward here her entire life. Unfortunately, due to her age, as we all know, we don't have money at that age. A monetary bond will not work for Ms. Glasgow. I am not familiar with her criminal history. I am hoping it's very limited. I do indicate she's never been arrested as an adult. There may be a juvenile matter or two, but as a result of a lack of adult record, we'd ask that the court take a chance on pretrial release.
Any failures to appear, Mr. Linder, in the juvenile record that you can see?
Yes,
Yeah,
multiple.
multiple failures to appear. All right, so what I will put her on pretrial release then. You live, Miss Glasgow, you live with your grandma?
Yes.
All right, you know what I'm gonna do? I'm gonna have someone from the pretrial division interview you. They're gonna get grandma's information, make sure, they'll call her. And you'll have to report to the pretrial office that's here in downtown Fort Lauderdale tomorrow. No, I'm sorry, today's Friday. You'll have to come Monday morning, okay? They're gonna help you to get back to court. Make sure that you get back to court and to see your assigned division judge. Does that make sense? All right.
Yes.
You want us to clarify the case first, or do you just want her to be out like standard pretrial?
Oh, thank you.
First, we'll take the verification, you can set a bond, she has the option of paying the bond, or we verify.
She'll wind up sitting in there all weekend if I do that. No, it's all right. I'll put her on standard pretrial. They're gonna send you home to grandma, okay? If you don't come to that office, if you don't show up on Monday morning, there's gonna be a warrant for your arrest and the whole thing starts over again, okay?
Okay.
So
Thank you,
make
Judge.
sure to show up to pretrial. They're gonna give you some paperwork before you're released, okay?
Okay.
Thank you.
The state is gonna request that the court, no victim contact.
Okay, all right, I will order that. No contact with the alleged victim in the case.
Your Honor, she's speaking, Corey, the judge needs to advise her or something.
Yeah, let me just tell her. So there's gonna be no contact with the alleged victim in this case. Her name is Heather Henriksen, okay?
Okay.
All right, all
Your Honor,
right.
there's actually a second listed.
The second listed victim? Oh, and also William Drew Cody, okay? So no contact with either of those folks, okay?
Okay.
All
Thank
right.
you.
All right, good luck to you. Thank you for the refresher. It's been a little while. We don't have pretrial down at South, so I almost never use it anymore. Okay, so let's see. All right. Okay, let's see here. There's a couple I'm gonna call out of turn here. On page 12, Antoine Blunt. Hi, Mr. Gaspard, how are you? Nice to see you. It's been a long time.
Yes, it has been, but Johnny Gaspard on behalf of Antoine Blunt, Your Honor.
Great.
I was hoping to get a copy of the police report real quickly.
Oh, sure. Let me just get, you can have mine, or if Mr. Linder has one.
I just got a copy.
Oh, you did? Okay,
Yes.
excellent. I gotta find my copy here, Blunt. Ah, here we go, Antoine Blunt. Okay, excellent. Do you need a couple of minutes to review it?
Yes, if you don't mind, guys.
Yeah, no problem. Mr. Blunt, I'm gonna call you in just a minute. Mr. Gaspard is gonna look over the police report, okay? Don't go too far, okay?
Thank you.
Good. And then, there's another one on page 15, Isaiah Calhoun, if he's here. He's got some family here? All right, good. Hi, folks, how are you? Let me just get down there. Calhoun. Here we go. Okay. All right. Hi, Mr. Calhoun. All right, sir. This is a very, very serious charge. You're charged with premeditated murder, as well as possession of a weapon or ammunition by a Florida delinquent or adult felon.
It's an attempt, Judge.
Okay, good. All right. And 19 years old. I'm, as I said to the other young man, I'm sorry to see you or anyone in this situation with these very, very serious charges. This is a warrant that was signed by Judge Bailey. Mr. Reedy, I'll allow you, if there is any argument as to the probable cause. I've reviewed the warrant. I would find probable cause for an attempt rather than, murder.
No argument as to probable cause for attempted murder, Judge.
All right. So I will confirm that finding that's been made by Judge Bailey. What's the state requesting here?
Your Honor, the state is seeking a finding of proof evident or presumption great for first appearance purposes only, and that Mr. Calhoun be held no bond. Your Honor, relying upon the arrest warrant and affidavit prepared by BSO Detective Morel Pelusia, Mr. Calhoun was identified by both the witness and the victim. There were multiple other witnesses, though they did not give sworn statements. They did identify Mr. Calhoun as the shooter. Both of the witnesses that gave sworn statements know Mr. Calhoun personally, the victim, for over 10 years. There's also video surveillance of the incident that corroborates the both witnesses' version of events, Your Honor. Additionally, and I imagine the PD may be making a request for the court, if you find proof evident or presumption great, to exercise discretion in not setting a bond. The state would be asking the court not to exercise discretion. He has a very lengthy juvenile history, which I can go into more detail if you would like. And just based on this act of violence, both striking the victim in the face with a firearm and then allegedly shooting her. Luckily, it struck her in the upper chest because I believe she, one moment, Your Honor. And fortunately did not result in more serious injury.
Yeah.
Judge, we would object to the court making a finding of proof evident presumption great at this stage of the proceedings. The state has introduced no evidence, called no witnesses. They've alluded to a videotape of the incident. They have not decided not to produce that for the court to review. Proof evident presumption great is the highest standard of proof that we have in the criminal justice system. Based on what the state has produced here today, especially what the state has not produced here today, we would argue that proof evident presumption great has not been established. If over our objection the court does find that proof evident presumption great has been established, we would ask the court to exercise its discretion and set bond for Mr. Calhoun.
Your Honor, if I may briefly respond, I believe the court is familiar with Brackett v. State out of the 4th DCA, in which the court specifically stated that the state may properly rely upon affidavits at a bond hearing in order to seek a finding of proof evident or presumption great.
Yes, it says that the court can. It doesn't say that the court has to.
No, and again, it says the state may the 4th DCA doesn't mention anything about the court. It quote unquote says that the state may properly rely upon affidavits.
All right. Thank you, gentlemen. I appreciate the arguments, and sir, I have read the warrant, which contains some very, very strong evidence and statements in this case, including from the alleged victim herself. For today's purposes, sir, for the purposes of first appearance only, I am going to find that there is proof evident presumption great of this charge. I'm going to hold you no bond on count 1, which is an attempted premeditated murder. Count 2 will be a bond of $100,000. I'm going to order no contact with the alleged victim. That includes any potential telephone calls, any communications from the jail. You will have an opportunity very soon to go before your division judge for what's called an Arthur hearing, which is a full-blown evidentiary hearing where the public defender or any attorney that you choose will attempt to have you released on some kind of monetary release, but for today's purposes, you'll remain in jail. It does speak highly of you that your family members are here for you today. They've been here for quite a while, and I know they're supportive of you. You will be assigned a regular public defender, or if you choose to hire an attorney, be in contact with them. All right, best of luck to you, sir. Take care. Thank you. Folks, good luck. All right, all set, Mr. Gaspard? Oh, hi, Mr.
Good morning,
Lawrence.
Judge.
How are you? Nice to see you.
How are you?
I
Good.
have Mr. Gaspard here. I'm just going to call his client, and then I can call you.
Hey, Franz, how are you doing? Good morning.
Fantastic. All right. And that was Antoine Blunt. There he is. Okay, wonderful, wonderful. All right, Mr. Blunt, good morning. Sir, you're charged with burglary of an unoccupied conveyance. Mr. Gaspard, any arguments as to probable cause?
Your Honor, I do see where they state that the alleged victim observed Mr. Blunt and another individual in the vehicle. At the time of the incident occurring and how they supposedly confronted the victim, the show-up seems rather iffy to me, and that's my only concern there, Your Honor, as far as the probable cause aspect. Based upon the reading, supposedly they saw them sitting in the vehicle. When they confronted them, both of them fled, and then they were able to 100% identify them several, and it doesn't say how far later, it just says shortly thereafter. We have no idea where they were arrested, how far from the location they were arrested. None of those things to help us truly determine whether or not Mr. Blunt was even party to this incident. It's my understanding Mr. Blunt even told the officers they could take his DNA. That's how much he knows it wasn't him, to check to see if he was any part of the vehicle. So that's where I am with that, Your Honor.
Okay, all right.
Well, first off, Your Honor, I think counsel's argument is better served at a motion to suppress, not necessarily first appearance. On its face, I believe the allegations do support the elements and gave the officer probable cause to believe that Mr. Blunt committed the offense.
Well, I agree. I'm going to find probable cause. I know your attorney very well, sir. He's going to make sure you get back to court. I'll release you on your own recognizance on this charge. You'll be released later today. Please be in touch with Mr. Gaspard, okay? You're going to have a hearing soon with your division judge.
Your Honor, request no victim contact.
Yes, yes. And, sir, just before you go, please have no contact with the victim, Norales Rondon, okay? All right. Best of luck to you. Good to see you. Good to have a great weekend. All right. Mr. McLaurin, it's nice to see you, sir. How are you?
I'm well, Judge. Good morning.
Oh, good morning.
Judge, I have Todd Kendrick on page 11 of the docket.
Sure. Let me get you on there. Todd Kendrick. Here we go. All right, fantastic. All right. Hi, Mr. Kendrick. How are you?
Good morning.
Good morning. All right. So you're charged with it's a violation of a county ordinance. It's basically it's a panhandling charge. I know you've had time to speak with Mr. McLaurin, who's an excellent attorney. I know him very well. If you want to, if this is a case that you want to work out today, Jara, I'd offer him a withholding court costs if that's something you want to do.
Judge, no, we're not going to resolve it today.
Okay.
Judge, I know you haven't been here in a while, but just to bring you up to speed, Judge, I've made the argument several times that this particular ordinance is not constitutional.
Okay.
I've filed motions to dismiss several times. Whenever it gets to court, the state usually drops it rather than have the hearing to determine the constitutionality of the ordinance.
Got it. Got it.
So with respect to Mr. Kendrick, I've given him my card. He has my information. I would ask that he be released on his own recognizance so I can file the appropriate motions.
Sure, of course, that's no problem. So, sir, I'm going to release you on your recognizance out to the community. Please keep in touch with Mr. McLaurin. Do you have a good address where they can send you the next date? Is this?
Yes, sir.
Okay, good. I see it here on the. All right, good.
It's 908.
That's not the right address.
All right, I'll get the correct address.
You'll get the address. All right, thank you, Jared. I appreciate it. All right, so you'll be released later today. Okay, good luck. All right. Any more, Mr. McLaurin?
No, Judge, that's all.
All right, nice to see you. Have a wonderful weekend.
Take care.
How about Nerlene, Terry, Augustin, Burton?
North Broward.
All righty. All right. Hi, ma'am. Good morning.
Good morning.
Let's see here. You're charged with possession of MDMA, also known as ecstasy, and you're also being held on a violation of probation warrant from a felony case. Excuse me, I'm sorry, that you have open with Judge Yusan. So what I'm going to do is I'm going to find probable cause for the new charge. It's a $1,000 bond on that case. Judge Yusan has signed a warrant for no bond hold on your open felony case, so you're going to see him on that case very soon, and you'll be able to address both, okay?
Honor, can I contact my public defender? There's a few things I forgot to tell him.
Okay, you want to speak to the public
Can I
defender
consult with
here
him?
today? Sure, sure.
Well, we did speak earlier. I advised Ms. Augustine that there's nothing the court can do about that.
Yeah.
No bond hold. She also has a total bond of $1,600 on counts 3 through 5.
Okay.
But is there something else you wanted to ask me, Ms. Augustine?
Yes, I have 2 cats and a dog at home, and they've been there since I've been here, and I don't want them dying while I'm in here.
Is there someone I can call to go check on them?
I'm sorry?
Is there someone I can call to go check on them?
My key is with my car where I left it, so.
Why don't you let me call you, okay?
Mr. Reedy is going to call you, and I'm glad you're concerned about the animals. Mr. Reedy's an animal lover. He'll make sure that everything is okay, okay?
We just adopted 2 kittens last week.
Hey, all right. Congratulations, Papa. All right, Mr. Reedy's going to call you now, okay? So you can go back over to the phone. All right, good luck. Joshua Barbosa. Hi, Mr. Barbosa. How are you?
Good. How are you?
I'm doing great, sir. All right. You're charged with domestic violence battery and domestic violence battery by strangulation. I'm going to find probable cause for those charges. I see the public defender is not standing next to you. Did you want them to represent you today? Oh, good. Okay. There he is. Wonderful. Excellent. Let me hear first from there's a victim advocate here in court. Have you had any contact with the alleged victim in the case? No contact. Okay, great. And let me hear from the state attorney.
Judge, just so while the state's thinking of their argument,
Sure.
this individual has retained Kelvin Kulik.
Oh, I know Kevin. Sure. I can call him.
Mr. Walker? Antonio Brown?
That's an old case for the battery. Do we still have this? No, that was in January.
So you hired him already, sir, for this case, for these new charges?
The old charge, the battery, that was in January.
Yeah,
This new case.
We were going to get to that, but.
Okay. So, all right, let me call Mr. Kulik, see if you left a message. Because I can always roll this to the afternoon. What time do they start now? 1 o'clock, right? The afternoon docket, not 1:30 anymore? Okay.
1 o'clock.
It's weird, I'm calling the office line. And nobody picked up?
Thank you for calling the law office of Kevin Kulik. We are currently unavailable. Please leave your name, number, and a message, and we'll get back to you as soon as possible.
I can look into
At the tone, please
I'll
record
roll
your
it- I'll roll it to the
message. When you
afternoon.
have finished
just want to put a
recording,
brief
you may
recall.
hang
I
up
have his-
or press 1.
I have his associate's
Cell?
number, Miss K, and I can reach out to her.
Oh, okay. All right, you want to call? I can put it on recall, and
Yeah, that's fine.
why don't we do that? Mr. Barbosa, have a seat. The state attorney's going to try to get in touch with your attorney. He's got some other numbers. We'll see if we can get him in here this morning, or maybe his associate, okay?
What is there trying to give me though right now?
He doesn't understand the battery allegation, Judge.
Yeah, because the battery was in January.
Okay.
Like the battery case was in January. I already resolved that case.
This is
I
a
don't know why I
different-
have another one right here.
Okay. Seems like a
Cause I already
different,
resolved that one.
it seems like a different charge. It's gonna be important that Mr. Kulik explain it to you. So that's why I'd really like to have him or Miss Kay here. Have a seat for a few minutes, we'll see if we can't get somebody, okay?
I can't go about like getting bond today or anything like that?
You can, and you can have the public defender represent you. What I'm trying to do, if you're telling me that you're,
Yeah, I want to get bond. I want to get out today. I'm not trying to be here. I got a job. You know what I'm saying? I got my apartment. I have stuff. You know, if I stay here longer, I'm gonna lose, and I'm not trying to lose anything.
right.
You know what I'm saying?
All I'm offering you, sir, is we can try to get in touch with your attorney. If you don't want to, if you don't want,
I'll use him. It's fine.
okay, all right, that is completely up to you. Do you want to chat with him for a couple of minutes?
Please, thank you.
Sure,
Please.
go ahead. All right, I guess never mind. If you know of any that are ready up north or right, call them quickly. I don't know if you have anyone in the pipeline. Yeah. Okay, no problem. Did the other young woman call you about the pets?
So parents were punished for probation, and the judge responded, doesn't need them to be present. Doesn't need some, no notice needs to be given, second warrant. I can't imagine it. 94806, and there's nothing that indicates it has to.
Judge, I don't know if you'd like to move on, and we'll recall that gentleman when we're done filling out, executing the paperwork.
Oh, sure. Yeah, I can do that. I didn't want you I didn't want to move too fast, if you needed time to speak to him, but I'm happy to, I can keep going.
Yeah, let's do that. Thank you.
All right, fantastic. JD, how are you, sir? Nice to see you. Everything good? Family's well? Yes, sir. Good. Glad to hear it, my friend. Nice to see you. Jose Estrella?
Approaching.
Great. All right, good morning, sir. You're charged with domestic battery by strangulation. You also have a violation of probation felony warrant. We're on hold for Judge Coleman. So I will set a bond on count 1 today, which is the domestic battery charge, but understand you will be held no bond on count 2, which is the violation of probation warrant, until you see Judge Coleman. I am going to find probable cause, though, for the new offense. Let me hear from the state attorney.
Your Honor, I'm going to be requesting a $7,500 bond order, no victim contact. I would also note it appears that Mr. Estrella also has a federal hold. He's a federal prisoner.
Oh, is that right?
Yes.
Okay.
I believe so, yes.
All right. All right, you know what, I'm gonna just set the $7,500 bond today. I'm gonna order, sir, that you have no contact with the alleged victim in this case. That is... They blacked it out.
Oh, I can get that.
Okay. All right, but I'm gonna order you to have no victim contact, and then at this time, you're gonna be held also no bond on count 2.
And I'm sorry, Your Honor, you can finish. I'll wait till you're done.
Sure, no, that's fine, that's...
Your Honor, I would ask if the court would be inclined to just order no victim contact. Certainly, if he is curious about the name, we can provide that to Mr. Reedy. He can provide it to Mr. Hill. Just with issues of Marcy's Law, I just have some concerns.
That's
about
fine.
it.
That's fine. All right, that's fine. And has the advocate been in touch with the alleged victim? Not yet. Okay.
But this is a not in custody case, so our office has been in contact, and I believe we've already relayed the name to the clerk, so the victim's name will be on the no contact.
All right. All right, sir. All right, and you are going to see Judge Coleman on October the 28th at 8:30 a.m. about that other state charge, okay? All right. Good luck to you, sir. Thank you. Jagdish Nanda?
That's a medical reset.
Med reset, okay.
Approaching.
Oh, he's coming up? No, I don't.
Sorry?
It's not my fault now.
Oh, no problem at all. Devante Camacho?
Yeah. He's here.
All right, very good. Hi there, Devante. How are you?
Good.
All right, good. Let's see here. You're being held on a warrant for a traffic violation. The charge is operating without a valid driver's license. Now, you might be eligible for the state attorney's driver's initiative program. I'm happy to release you on your recognizance on this case today, so that you can go back to court. This will be up in the. Is this a North case?
Yes, sir.
Yeah, this is up in the North Satellite. I would make you an offer to resolve it today if you want. It would just be a withholding court cost, but there's a possibility that you could have this case dismissed by being in the state's diversion program. So it's completely up to you.
Judge, at this time, you'd be willing to accept the court's offer?
Okay, all right, so just be a withhold. The court costs are $293. You think you could pay that within 6 months?
Yeah.
All right, very good, sir. Good luck to you. You'll be released today, okay? This case is all done. Okay, very good. Francis Albert Gill.
Approaching.
All right.
Since they initially sent the report.
Here. Hi, Mr. Gill, how are you?
Good, sir. How are you?
Good, good. I'm just looking at something here. Whose case is this? Do you know, Mr. Linder?
Yeah, it's Judge Levy. What this is a failure to appear to VOP. Mr. Gill was actually given an ROR on the original violation.
Okay.
And then failed to appear to the VOP hearing.
To the VOP. All right. I really can't touch it. So, sir, you're being held by Judge Levy on it's a misdemeanor traffic warrant. It's a driving under the influence is the charge. That's why I asked the state attorney who the case belonged to and what the case was about. You also have 3 other they're regular traffic warrants. The charges are a bad sticker on your plate, operating with a suspended license, 2 counts. I really cannot touch, you're being held without bond by Judge Levy, and I can't really touch that because it's a violation of probation. Okay, the good thing is you already have a hearing set up with Judge Levy on that and on your other charges, October the 28th at 10:30. So you will see her, but unfortunately for now, you'll just remain in the main jail until you see Judge Levy, all right? I wish you the best of luck. The bonds on the other charges are $500. I'm going to leave those in place so that you earn gain time on those charges, all right? Best of luck to you, sir, and you'll see Judge Levy soon.
Thank you, Judge.
All right. How about Jarrell Neal? All righty. Hi, Mr. Neal. You're charged with giving false identification to law enforcement And I'll just release you on your recognizance on this charge. There's a Fort Lauderdale address on here. Is that a good address where you can get mail?
1901? 1901?
No.
Northwest 16th Court?
No, it's actually...
16th?
It's actually a different address that they have for you. Oh, no, yes, okay, yes, 1901 Northwest 16th Street. Is it,
All right, thank you.
is it Northwest 16th Street or Northwest 16th Court?
16th Street.
Street, okay, good. They're going to send you a court date in the mail. Please make sure you come to court, otherwise there'll be a warrant, okay?
All right, thank you.
All right, good luck to you. Brian Winter?
Approaching.
Winter. Right over here, man.
All right, hi, Mr. Winter. All right, let's see here. So, sir, you're charged with petty theft. So you have a few choices for today. I'll find probable cause. Oh, he's on pretrial?
Yes, sir.
Oh.
He was placed on pretrial on October 10th before a judge for aggravated assault with deadly weapon without inflicting bail in case number 19012225 CF10A. Pretrial is asking that you revoke his pretrial.
Oh, dear. All right, let me hear from the let me hear from the state attorney, and then I want to hear from the PD before I make a decision on revocation.
Madam Pretrial, when was he placed on pretrial? Yeah, Your Honor, my concern is he was unable to go really much more than 2 weeks after being graciously let out on pretrial on a violent offense by Judge Powell without committing a new law offense. I just don't know how the court can have much confidence that he will not commit another offense if released again.
All right, let me hear from the state attorney. I'm sorry, from the public defender.
Thank you, Judge. And forgive me for not having the information contained in the probable cause affidavit.
Oh, no, it's fine. It's a pretty simple charge. Allegedly, he reached behind the counter, grabbed some cigarillos and a beer. Total value $15.25.
With that specific case, not the one where pretrial was revoked, would the court be willing to make an offer on this matter for time served?
Oh, of course. Yeah, no, I'm happy to make an offer on the case. It'd just be a withhold in court costs.
Your
Yeah.
I would just ask if he's going to be taking a plea that he be advised that this plea can be used against him in, as a violation. Not just if the penalty case is resolved, but then it would certainly be considered a violation of his pretrial release conditions.
Right. I mean, I'm also happy to ROR him on that charge, but although it gets a little complicated because he's got the pretrial issue. Now, I'm inclined to revoke his pretrial, but I'm inclined to set a bond on that charge. I wouldn't hold him no bond. It may be better. Listen, do whatever your public defender says. It might be better for you not to resolve the petty theft today, but that's really up to you and your public defender. The offer on it is a no contest and a withhold of adjudication. It might hurt you though in the aggravated assault case.
Judge, if possible, could we ROR Mr. Winter on the case before the court on the docket? And as far as the aggravated assault, I will make sure the assigned attorney is contacted to have a hearing regarding bond, because a financial bond will not work for him.
Okay.
So we will have to possibly a halfway house or something we could put together for him and present that to the court.
All right, that's a good idea. All right, so I'm going to revoke the pretrial today. For now, it'll be no bond. Hopefully, your public defender can put together a package for you that is it Judge Garcia Wood, you said? We'll find acceptable, and I'll release him out of recognizance on the petty theft charge. Okay.
Thank you.
All right. Do you need this order back, or I give it to the clerk? Yes. All right. Thank you. Sorry, I'm a little rusty. All right. Seth Angelo.
He's present, Judge. Thank you.
All right, very good. All right, good morning, Mr. Angelo. You're charged with stalking or harassment. I'm going to find probable cause for the charge. Any criminal history, Mr. Linder?
No, Judge.
Okay.
see.
And you have nothing, Mr. Linder, right?
I'm pulling it up.
Oh, okay, you're pulling it up, okay.
I don't see anything, Your Honor.
Okay, all right, so no criminal history. What's the state seeking?
Your Honor, I do have a concern. Based on these allegations. He admitted to his being at the location on 3 separate instances where this victim was. That is would be awfully coincidental that he happened to be at the same location as the victim on 3 distinct different days, one on August 24th, another on October 19th, and another on October 24th. There is reason to believe that Mr. Angelo is stalking and following this woman. So in light of that, I'd be requesting a $5,000 bond, but I would also be requesting, should he post bond, that he be supervised by pretrial release with a GPS monitor and an order of no victim contact, no firearms or weapons, no further order of the court.
All right, let me hear from the public defender.
Thank you, Judge. As the court is aware, Mr. Angelo has no prior arrests nor criminal history. He's a Florida resident his entire life. A lot of it was spent in Palm Beach, but he's been in Broward since 2017. He is a math tutor. He is in the process of obtaining a full-time job as a teacher. He lives with his girlfriend. The allegation of the stalking charge, I was made aware, is a stranger. This person is not known to him. For that reason, and again, I did hear that they've had contact at least 3 different times in the same area. He did indicate to me that places like the gym, Walmart, and Walgreens that he goes to every time he happens to, see this person. So I don't believe there was any mens rea to be charged with stalking, not to be charged, but to actually be guilty of stalking. Based upon this information, Judge, and his lack of history, I am going to ask the court to forego on a monetary bond and place him on standard pretrial, because a ankle monitor would hurt for purposes of teaching children in school. He would not be able to do so.
And, Your Honor, and respectfully to Mr. Hill, he hasn't seen the PC affidavit. I didn't mention certain allegations that the court is aware of, but as the court can see, there are certain comments that were made that reasonably one could argue the mere interaction on 3 different dates was not coincidental, that there was an intent on Mr. Angelo's part. And I would know at least on one of the incidents, she had her 1-year-old child with her.
Yeah, I noted that. It's a concerning case. It's an unusual case. This gentleman is a math tutor, you said? That's what he does for a living?
Correct.
Okay.
That score at the top.
All right. It's an unusual case, and he has no criminal history, but these allegations are very concerning. All right. I'm going to set a $1,000 monetary bond. I'm going to put you, sir, on pretrial release level 2. So I am going to have him on an ankle monitor. He can be on an open schedule, but you're to have no contact with the alleged victim in this case or her minor child. So if you go to the same gym and you walk into that gym and you see her, you walk out. If you go to the same Publix and you see her, you walk out of the Publix, go shop somewhere else.
And Your Honor?
Yes, sir.
I would just ask, based on the specific allegations in this case, that the no contact order or the GPS also include not just where she resides and place of work, but any place she frequents.
Yes, no, absolutely, I agree. I mean, I'm fine with him going to, like, for instance, this gym if she's not there. If she's at the gym and he sees her.
The problem with that is, Your Honor, is really, I don't think, based on these circumstances, that she should have to be anywhere around him, even in his presence. And which would, based on that order, he would be allowed to go there, see her, then turn around and walk away. What I'm saying is, frankly, there's plenty of gyms out there. If she frequents this gym, I don't think it's, considering what's going on here allegedly, I don't think it's that unfair and inconvenience for him to find another gym to go to.
All right, I'll include the gym, but I think that's it. We can't include Walgreens, Walmart, et cetera, et cetera. If he sees her, go out. But if it's the same gym, then pretrial include in the GPS monitoring 8942 State Road 84. All right. All right, sir. If you go anywhere near this young woman, her child, anyone, you'll be immediately rearrested. Do you understand that?
Yes, sir.
All right, sir. Good luck to you.
Your Honor, and lastly, just as far as the state's, sir,
Wait, hold on. Come back one second.
As far as the state's request for no firearms or weapons.
Yes, that's granted. No firearms, weapons, etc.
I don't have that.
All right. All right. Good luck to you, sir. All right. Stephen Morris. Medloan. Okay. Shamar Edwards.
Main jail.
All right. Hi, Mr. Edwards. How are you? You're charged, sir, with giving false identification to law enforcement, resisting an officer without violence. You also have a misdemeanor warrant. Charge on that warrant is resisting an officer without violence. Whose case is that? Division
It's
MH.
Judge Pohl, Your Honor.
Okay.
And I can tell you, unfortunately, Odyssey's down, but I can tell you that I see so far at least one prior failure to appear before this. The reason I was checking for that is Judge Pohl isn't normally the type to issue a no bond.
Yeah, no, I know. I know. I'm going to let Judge Pohl deal with it. I really can't move his bond. So, sir, it'll be a $100 bond on count 1, no monetary charge on count 2, and you're going to see Judge Pohl on the 28th at 8:30 about the other charge. All right? Best of luck to you, sir. You take care of yourself. Ashmead Crichton.
Conti, Your Honor.
Oh, great. Hey, how are you, Deputy? Nice to see you. Everything
Nice to see you too, sir. How you doing?
I'm doing great. Your family's well? Everybody's good?
Yes.
All right,
Everybody's
good. Pleasure to see you. All right. Mr. Crichton, oh, sir, I have bad news for you. Unfortunately, you're being held on an immigration hold by ICE, by the federal government. There is nothing I can do about this warrant today, so you're going to be held no bond at the Conti facility, and when they're ready, they will pull you in for a hearing in the federal court on that, okay?
Okay, sir.
All right, best of luck to you, sir. I hope everything works out.
And
God
Your Honor,
bless.
if
Yes.
you can inquire, just so I could pass my DV paperwork along.
Sure.
Is the defense ready to proceed on Jose Estrella?
Oh, you're all set, sir. Go ahead. You're all set. Jose Estrella?
I think that was put on recall for
Joshua
No, I mean,
Barbosa.
that's what I meant.
Joshua
I meant
Barbosa. Yeah,
yes,
Joshua
yes.
Barbosa.
We should be ready.
Okay, great. All right, so I can recall Mr. Barbosa.
Yes, Judge.
All right, great. So you've had a chance to speak with the public defender, sir?
Yes, sir.
All right, and I just want to confirm you don't want me to try to contact Mr. Kulik at this point. You want to go ahead for the purposes of this hearing with the public defender.
I spoke
I
to
just want to get out.
I spoke to Mr. Kulik's office. They indicated they will not represent Mr. Barbosa.
Oh, well, there you go. Okay, all right. So let me hear then first from the state attorney, because I haven't heard from the state yet.
Thank you, Your Honor.
I didn't call her yet. I didn't know. Yeah, I didn't. Yeah, they know it's okay. Yeah, y'all. I didn't call him for this case because I just happened yesterday. So
Okay.
I didn't know him.
Okay.
Yeah.
I'm going to be requesting a $2,500 bond on count 1, a $10,000 bond on count 2 in order of no victim contact. Mr. Barbosa is currently on probation before Judge Levy for battery. He was placed on 6 months probation a month ago. The allegation in that case is that he punched his female roommate in the mouth, causing a minor laceration to her upper lip. And in addition to all that, based on these allegations, I do have safety concerns for the alleged victim in this case.
Okay. All right. Let me hear from the public defender, please.
Yes, Judge, at this time, we would ask the court, based upon Mr. Barbosa's financial situation, to lower the bonds a little bit. In speaking to him about his financial situation, he is a barber. He's 32 years of age. He does work 7 days a week as a barber. But unfortunately, a total of a $500 bond to bond out would be financially hard for Mr. Barbosa to do. He's asking the court if the court would consider a $1,000 bond on count 1 and a $1,000 on count 2.
Okay. All right, I'm gonna do a $2,000 bond on count one. I'll make it a $10,000 bond on count two. I'm gonna order no contact, sir, with the alleged victim in this case. I'm also gonna place you on pretrial release. Excuse me, everybody's gonna be level two, okay, with a monitor.
Pretrial release, put you on an ankle monitor.
Okay, but they can put me on pretrial, right?
They put you on pretrial with an ankle monitor. Yeah.
All right, good luck to you, sir. Alfred Vickers.
Thank you so much. I appreciate
All right, take care.
you.
All right, Mr. Vickers, good morning, sir. You're charged with burglary of an unoccupied conveyance. I'm going to find probable cause for the offense. Oh, it's a young man. Any priors? Okay. He's a co-defendant of the other gentleman that Mr. Gaspard is representing?
Yes, Judge.
Still looking for his paperwork. Your Honor, frankly, if the defense wants to provide some information, that's fine. Well, we don't have to just wait for me.
All right, well, honestly, if there's really not significant priors, I'm just going to release him just like the other young man.
Let me just look for.
Okay.
Oh, there it is. I can tell you, I don't see any adult priors in Broward.
Okay, I'm going to release you, sir, on your own recognizance. Please, they're going to send you another court date. It's very important that you make sure that you appear, otherwise there'll be a warrant, okay? But you will be released today.
No victim.
Thank you, Judge.
Yes, and no contact with the alleged victim in the case, okay? Good luck.
Thank you.
All right, good luck. Terrion Bryant?
Yeah.
Terrion Bryant? Terrion?
Approaching.
Oh, great, thank you. All right. Hi, Mr. Bryant, how are you?
All right, Your Honor.
Good. Let's see here, sir. You're charged with driving with a suspended license, license not carried or exhibited, unlawful speeding in a school zone, and you have 2 out-of-county misdemeanor warrants. What I'll do is, I'll find probable cause. I'll release you on your recognizance on the Broward County charge. I can't do anything about the other holds, though. Those are out of Miami-Dade County. So count 4 is a $1,500 bond. Count 5 is a $570 bond. And on the traffic tickets, there's no monetary bond. So you're released on the Broward charge. Doesn't mean that case is going away. You will get a court date for that case, okay? All right. Good luck to you, sir. Have a great day. Katie L. Smith.
Approaching.
Great. All right. Hi there, Mr. Smith. Let's see. You're charged with burglary of an unoccupied conveyance. There was an arrest warrant that was signed and confirmed by Judge Tobin Singer, so I'll find probable cause. She had set a $50,000 bond. Is the state asking me to keep that in place?
I am, Your Honor. There are, I believe, aggravating factors in this case, considering that AR-15 magazines and another magazine for a Glock were stolen from the home. It is referenced in here that at the time the warrant was signed, that Mr. Smith was in Palm Beach on, I'm checking to see what that matter was about.
He was in custody in Palm Beach?
Yes, he was on a, one moment. It was on a juvenile matter on a identical offense. He
Also with a police cruiser?
No. Offense, not the specific facts. Yeah,
okay,
yes.
I see.
Your Honor, but there has been, one moment. I count. From what I can tell, secure detention has been ordered in the past.
Okay. I may need to hear about his juvenile record if there's other, you said there's other like offenses?
Yes, sir.
Any violent offenses?
Not per se violent, just
Similar.
related to this, charge.
All right, let me hear from the public defender's office.
Judge, I had the opportunity to speak with Mr. Smith this morning. As you can see from the docket, Mr. Smith is still 19 years of age. He indicated he was in custody in Palm Beach County for 56 days. He indicated he received time served on that matter. I cannot verify that. I don't have access to those records. He does live with his mother and his two sisters. He's not employed at this time. Would the court, due to his age and the fact he's not working and having an income, would the court consider pretrial release with an electronic monitor in this matter?
You know, it really pains me. It hurts me physically to see a 19-year-old young man in this situation. I just have a group of students that just walked in just now, and I hate that they have to see you like this, sir. I'll reduce Judge Tobin Singer's bond down to $25,000 instead of $50,000, but this is a very serious allegation, and especially that this involves a police cruiser and weapons allegedly being stolen. I'll reduce it down to $25,000, and I think this has to be fleshed out a little bit more in division. You'll see a division judge soon, a felony judge, and you'll have an assigned public defender there. I'll be able to delve into the case a little bit more. All right. Good luck to you, Mr. Smith. All right. Before I call on the next case, I want to say hello to the students. Welcome. So you're students from the 7th grade in North Lauderdale, is that right? Wonderful. Well, great. Good. Welcome. It's very nice to see you all. I'm Judge Davis. I'm a county court judge here in Broward, and this is the first appearance court. So what you're seeing today is there's folks that have been arrested on all kinds of different charges, and they have the right to see a judge within 24 hours of getting arrested. That judge today is me. I used to do this full-time, this work, seeing everyone who's been arrested. Now I'm just a regular judge. I have a regular division in the Hollywood court, and I'd love to have you all come and visit me in my regular courtroom one day. My job today is not to decide if anyone is innocent or guilty. Everyone here is innocent until proven guilty. That's the law. My job is to read the police report, decide if the police made a proper arrest in the case, if there's what's called probable cause under the law for the arrest. And if I find that there was probable cause, it's my job to set some conditions of what's called bond, also bail. That can be either money that someone would have to pay to get out of jail, or I can put some other conditions on them to make sure that they're safe and that the community is safe and to make sure that they get back into court. So it's really interesting. Unfortunately, I do see a lot of young folks who come in through here, and that's difficult. I do a lot of work with young people in the community to try to prevent people from having this situation before it even begins. So I'm so glad that you're all here today. It's really wonderful. It's a blessing. And I don't know how long you'll be with me, but if anyone has any questions, we'll hopefully have some time at the end. Maybe I'll take a few other cases and then see if any of you have any questions for me. All right? Thanks for being here, folks. All right, let me call up Robert Lewis. All right. Hi, Mr. Lewis. You're charged with burglary of an unoccupied conveyance and trespassing. I'll find probable cause for the charges. This looks like the third co-defendant in that other...
It's a second of...
A second co-defendant?
Yes.
Okay. Any priors?
One moment, Your Honor.
Mr. Captain?
The defense believes it should just be one trespassing charge. Should.
I'm not showing any history, Judge.
Okay. You think the burglary charges is a misprint?
No. I wasn't going to mention it because it was dropped. He had a previous arrest or trespassing case, but it was dropped.
But it was dropped. Okay, yeah. So it is. It's just one trespass. Just one trespass. What did I do with the other co-defendant? Do you remember?
ROR, was it, Latavia, was it ROR?
Yeah, I think it was ROR.
I believe it was.
I think it was ROR pre-trial.
No, Glasgow. I believe it was. She's staying with her grandmother.
Staying with grandma, yeah, yeah. I remember. Okay, I'm gonna do the same thing. I'll release this young man to custody of pretrial. So, sir, what'll happen is you'll be released from jail today. Monday morning, you're gonna have to go down to Fort Lauderdale to the main office of pretrial release. Follow all conditions. They're gonna monitor you and make sure you get back to court, okay?
Again, Your Honor, just request an order of no victim contact.
Yes, and no contact with the alleged victims in this case. There's two. It's Heather Henriksen and William Cody, okay? All right.
Thank
all right.
you.
Good luck to you, sir. You take care of yourself. How about Denzel Glasgow?
He's in North Broward, Judge.
North Broward, okay. All right. Hi, Mr. Glasgow. Let's see here. You're charged with burglary of an unoccupied conveyance, grand theft auto, and resisting an officer without violence. I'm going to find probable cause for the offenses. So he's number 3. This is.
Yeah, I believe that's correct,
Except
Judge. Yes.
he's in a little bit of a different situation, Your Honor.
Okay, talk to me.
He's currently on juvenile probation and conditional release for like offenses.
Does this violate his probation?
It certainly potentially could.
It may. Okay. All right. Mr. Reed, have you had a chance to speak with him?
I did, Judge. I can tell you, excuse me, Mr. Glasgow has been a resident of Florida for all of his life. He's actually stayed at the same place all of his life. He's lived with his grandmother the entire time. He does have, as the stated noted, some juvenile priors. He works at the Bonefish Grill as a busser. He's been there almost a year, makes about $150 every 2 weeks. He's also going to school. He's a senior at Blanchely High School. Grades basically B's and C's, mostly B's. He does not have any money set aside to enable him to post a monetary bond. He also indicated to me that he has a medical condition that requires a great deal of attention. He's diabetic, and he is not right now. He is not getting the medical assistance that he needs in the jail, which concerns me greatly. Because I know that he can get the proper treatment if he is not in custody. I know his situation's a bit different, Judge. No warrant has been filed on the juvenile probation as of this point, as far as we know. I would ask the court, in the light of all those circumstances, to release Mr. Glasgow on pretrial release.
Your Honor, certainly if Mr. Glasgow does remain in custody, the jail certainly can provide him the proper treatment. He would not be the first diabetic to go to the jail. What I would note, just sheer number, if you look at charge 1, 12 priors in that type of offense.
12 juvenile priors?
As a juvenile. That's not counting other offenses, just that type of offense.
How many convictions on the 12, do you know?
I'll have to count through them again. Well, let me put it this way, Your Honor. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. Let me put it this way. He's been adjudicated delinquent over 20 times.
Who's his judge now? Who's he on probation with, do you know? Judge Williams?
It doesn't say that, and I just have the DJJ page I have doesn't say who he's actually in front of. I mean, you can inquire Mr. Glasgow, and that's not incriminating. It's a matter of fact.
Do you happen to remember the name of your judge that you see in the juvenile court? Man, woman?
Stacy Schulman.
Judge Solomon. Okay. All right. Good. She's dependency, isn't she?
Yeah. No. It's Stacy.
Stacey Ross. Probably Judge Ross. Blonde hair.
Stacy Schulman.
Stacey Schulman.
Okay. I'm being advised. Your Honor, my colleague here is in our juvenile unit is advising that they will handle both sometimes.
Okay. Yeah. She could have a crossover case. Ay, Denzel, what am I supposed to do with you? You have yourself in quite a pickle. So you live with your grandma?
Yes, sir.
And you're in high school, you're a senior
Yes, sir. I'm attending school and I work also.
at Bonefish. What are your hours like at Bonefish Grill? What shift do you work?
I work night shift.
The night shift? So like
Yes,
seven,
sir.
like 3 to 11, that kind of thing? Or 7 to
Well, 3 to 12.
3 to 12? You have a car, you drive, or you, how do you get there?
I have my mother to drop me off. Or I catch an Uber.
How do you catch an Uber?
I would also just note, and this is for bond purposes, the very last page of the report, Your Honor, while at this time he's only charged with one count, his other co-arrestees provided additional information about Mr. Glasgow.
Ay. Denzel, I really don't know what to do with you. I really don't like seeing you sitting in jail, that's for sure. You have an angel face, you know that? I can't believe that that you've been adjudicated delinquent 20 times. Here's what I'm going to do. I'm going to put you on pretrial release. I'm going to put a ankle monitor on you, and we're going to have you on a very, very strict schedule, Denzel. A very strict schedule. The places that I want you going are to school and to work.
Yes, sir.
That's where you're going to go. So you're going to go to school. After school, he's going to go immediately home. Then he's going to go to his work shift. After his work shift, he's going to go immediately home. And that is it. You're going to be in your house with grandma. You're going to be studying. And you're either going to be at work or you're going to be at school. Just those two places. If you are anywhere else, the GPS monitor is going to pick it up. And then you're going to be immediately rearrested, which nobody here wants to see. Nobody at all wants to see that. So right now, your focus has to totally be on school, and then work, and then that is it. Otherwise, you are home. Okay?
Yes,
And
sir.
the GPS will be on there all the time. If you try to fiddle with the GPS, they're going to know automatically, and then that's an automatic rearrest. You're just going to wind up right back in here. Now, I know you're familiar with the jack. Obviously, you've been there a lot of times. This is very different than the jack. You are now in adult jail. I don't know if this is your first time in adult jail, but it's a very, very bad place to be. So pre-trial, I want you to watch Denzel like a hawk. He's got a very strict schedule. When you interview him, I want you to find out what his work hours are, his exact work shift. And I know things change at work, so you're going to have to notify pretrial in advance a week of your work schedule, so that way they can adjust. If you have a different shift one day, so that they will know exactly where you are and what you're doing. Because I don't want them to get a false, monitor that you're somewhere else where you're not supposed to be. If you're at Bonefish, I want them to know it. Otherwise, you're at school and you're at home. Okay? Is that a deal?
Yes, sir.
All right. Now,
Yes, sir.
I don't know what Judge Schulman is going to do. Judge Schulman may put you back in custody. But for now, I'm going to take a chance on you because I know you don't want to be in adult jail. It's not a good place to be. We're going to give you a shot. Pretrial is going to affix the monitor today. They're going to interview you. They're going to find out your schedule, and then we'll give it a try, okay?
Yes, sir.
Please, I'm begging you to try and stay out of trouble. And we'll see what Judge Schulman does. And then this case is going to go to a regular judge, a regular division, and you're going to have to deal with it, and we'll see what happens, okay?
Okay.
All right.
And Your Honor, just ask for no victim contact.
Yes, I'm going to order no contact with the alleged victims. Their names are Heather Henriksen and Dina Marie Cody. All right, Denzel, really, I believe in you. Good luck. I really, really hope things work out, okay? God bless you. All right.
God bless you.
All right, take care. Let me go off the record for a minute because I want to see if these students have any questions. We'll just take maybe a 5-minute recess, and then I'll come right back, okay? All right. discussion with all these wonderful students and their bright, shiny faces. Here we go. All right, let me call Roy Gilroy. Hi, Mr. Gilroy. Let's see, sir. You're charged with false imprisonment of a child and robbery by sudden snatching without a firearm. I'm going to find probable cause for the offense. The offenses, I should say. Any priors here, Mr. Linder? Okay.
Mr. Davis, Judge Davis?
Yes, sir.
I was just told about these charges. Now is when I've been told about them.
Okay.
I just wanted you to know the whole story as to how I came onto these charges.
Okay.
I would not be discussing the facts of the case if I were you, sir.
Before you good. Before, and let me just remind you, because I read it, I let everyone know what their rights are at the beginning. I know you're a public defender, but let me say again, as I just told the students, the amazing thing about America is that you have the right to remain silent. No one can force you or make you say anything. So I know that you want to have a discussion with me, and I will not.
Your Honor, it's not a discussion. It's a simple explanation of how the cards have been played on the table here.
Okay.
I came into this situation on a Sunday and was called into Plantation Police Department to be asked questions. At that time, I wasn't read my rights. I was simply put into a car, brought down here to the county jail. I am now becoming aware of the charges, and as far as the charges are concerned, I understand that the child is 14 years old. So I just wanted you to be aware of the situation, because I do have a prior that this is one that I simply cannot afford. And my only request is pre-trial. And I'm willing to put an anchor monitor on, sir, so you will know where I am 24/7. I live a very simple life. And, you know, I would like to have an opportunity to say I'm sorry if I have hurt someone's feelings. You know, but I would like to have my word heard this time, not like the last one that pretty much destroyed my life, sir. Okay?
Okay. All right. I appreciate that. I truly do. I'm gonna speak a little bit to the state attorney. Then the public defender may have some information that he wants to give me, and let me hear what the state attorney has to say.
Your Honor, well, first off, I'm going to be requesting a $25,000 bond on count 1, a $10,000 bond on count 2, no victim contact, no contact with any minors, no possession of any firearms or weapons, pretrial release of the GPS monitor. First, I would note, Your Honor, I am concerned about these allegations. I won't put it on the record, but the court is familiar. There are other issues going on here. I recognize that they're documented, and while I agree that is a concern, I do believe at this point in time in first appearance, the safety concerns for the public outweigh the other issues right now. I would note Mr. Gill's prior is a 2013 case where he was convicted on 2 counts of aggravated assault with a firearm.
This is a case that could potentially go to Judge Porth.
I mean, that
it's a possibility.
Judge Matthews had this case.
And that's the thing, Your Honor. I can tell you, his last case, I don't believe. Yes, the previous case, which was his probation, was resolved as recently as 2017, was before Judge Fine. So he pled out the case. There were no issues of competency preventing him from taking a plea in that matter.
Okay.
He went through probation outside of a mental health court.
Okay. All right. Let me hear from the public defender a little bit.
you, Judge. As you've heard from the state attorney, it looks like Mr. Gill does have a very limited history with the system. If I heard correctly, it looks like the last offense was 2013. He is a part-time handyman. At this time, unfortunately, doesn't have any money saved to post a monetary bond. Due to his financial situation, he is back home living with his parents as well. He's been in Broward for 5 years. He was in Palm Beach before that for a lengthy time. We do believe he has strong ties here to the community, both job and family. You heard Mr. Gill ask in his statement for pretrial release, and that's what we're going to ask judges to forego on monetary bond and place him on level 2 pretrial release.
What was it you were asking for again, Mr. Linder? I'm sorry. What was the monetary bonds?
25 on 1, 10 on 2. The GPS, no victim contact, no contact with minors, no possession of any firearms, weapons, ammunition.
All right, here's what I'm going to do. I'm going to set a $15,000 bond on count 1 and a $7,500 bond on count 2. If you do make those bonds, I'm going to place you on pretrial release. That'll be level 2. I'm going to order as part of the pretrial you have no contact with the alleged minor victim in the case. I won't mention the name aloud on the record, and no contact with any minor children. And you will see.
Even my niece? I mean, I can see my niece.
Even family members?
I don't have any issue with biological.
Excluding family members. That's fine. Family members are okay. Family.
Your Honor, I'd also just ask, as far as the no return conditions, that also include Terra Park.
That's fine.
And Plantation.
Yeah, that's fine. We'll include that in the pretrial and the no-go zone, 11600 Tara Drive in Plantation. All right, sir. Good luck to you. You will have your day in court. I promise you, you will have an assigned public defender and follow all of their recommendations. And good luck to you. I hope everything works out. Yes.
Firearms and weapons.
Oh, yes. That's also no firearms and weapons. Okay. All right.
Thank you.
All right. Good luck.
Just give me 1 second.
Okay. Pretrial. I'm keeping you busy today. Cortez Walker. Thank you, kids. It's so nice to see you all. Have a wonderful weekend. Good luck. God bless you. Thank you all. All right. Hi, Mr. Walker. You're being held on, you've got 3 violations of your felony community control. You also have a few misdemeanor warrants. The bonds on those warrants are $500 per count. You have 2 hearings coming up, one in felony court. That's going to be October 28th at 8:30 a.m. And then the misdemeanor status will be October 29th at 9 a.m. You'll see both division judges, okay? For now, on the felony warrants, though, you're going to be held no bond, okay?
Okay.
All right.
Thank you, Judge.
Good luck to you. James Fluellen?
Medical reset.
Okay. How about Semi Mitchell or Kemi Mitchell? I'm sorry if I'm mispronouncing.
Approaching.
All right, very good. Hi there, sir. How are you?
Blessed and highly favored.
Good. Oh, good. I'm glad to hear that. You're being held on a you have a petty theft charge. That's a misdemeanor. It's a $25 bond. You are being held, however, no bond on 1, 2, 3, 4 violations of probation. So I'm going to leave the bond in place. You have a violation of probation hearing coming up with your division judge October 28th at 8:30 in the morning, okay?
Okay.
All right.
Can I ask you a question?
Yes, of course, sir.
You said violation of 1, 2, 3, 4. What all that? What you talking about?
Judge, I have that in front of me. If the court would like, I can explain that to him because I have it here written on the docket.
Yeah, I think that'll be better. And you'll see, it looks like I think it's Judge Casey, is it?
Right.
All right. Yep, you'll see him soon. And listen to your public defender. It's better that he explain it to you than I do it over the air where everyone can hear. Yes.
Thank you, Judge.
All right, thank you.
Mm-hmm. It's only count 2. Okay, all right, so I can dismiss 3, 4, and 5. Okay, sure, great. That makes sense. That's why he was confused. Antonio Brown. I imagine it's not the Antonio Brown. Otherwise, we'd have a lot more, we'd have a lot more press in here. Hi, Mr. Brown, how are you? Let's see here. You're charged, sir, with aggravated assault with a deadly weapon. I'm going to find probable cause for that offense. Mr. Linder, any?
Your Honor, I'm going to be requesting a $10,000 bond, no victim contact. First, I have concerns about Mr. Brown's ties to the community. Both the PC affidavit and booking show his residence is in Tampa. Mr. Brown has been to state prison out of Leon County. He was a 2011 felon or adjudicated delinquent unlawfully in possession of a firearm, concealed weapon, or ammunition. He was sentenced to 4 years and 6 months state prison, released January 15th, 2016. Additionally, in 2009, out of Duval County, strong arm robbery, 12 months in state prison. Just noting the offense out of Leon County also causes concern, considering one, while he wasn't charged with it, he was allegedly threatening a victim with a 12-inch bayonet type knife, I believe. One moment, Your Honor. I believe he was found in possession of the knife. Yes, he was seen in possession of the knife. He certainly could be facing an additional charge again of possession of a weapon by an adjudicated delinquent or convicted felon. So, Your Honor, obviously I'd be asking for no victim contact and no return to the incident location at 2601 North 29th Avenue in Hollywood. That is a Days Inn motel.
Okay. All right, let me hear from the public defender.
Yes, Judge, thank you. At this time, with the brief time I had to speak with Mr. Brown, as the court did hear, he has ties to Tampa. However, he does have family here in Broward. He does plan on staying here in Broward for the time being. So as a result, he does have a valid address. And with that, he's asking the court if the court would consider pretrial release in lieu of monetary bond.
All right. All right, sir, I'm going to set a $10,000 bond, and if you do make that bond, you'll be on pretrial release. That's going to be a level 2 with a monitor. No contact with the alleged victim, no firearms, weapons, or ammunition of any kind, sir. All right. Best of luck to you.
Yeah, we have to go to your real judge to do that. That's going to take some time. That's going to take a week.
James Clee.
Approaching.
All right. Hi, Mr. Clee. How are you, sir? You're charged with possession of heroin, operating without a valid license. You have 2 traffic warrants. They're in my division. They belong to me. And you're also being held on a parole violation. That charge is a no bond hold. I'm inclined to leave everything in place right now because I don't want anything. You know, I'm happy to resolve your traffic cases, but I don't want any of that to affect your felony charge, and certainly I don't want it to affect the parole.
And additionally, Your Honor, the parole violation is out of another state.
Oh.
So even if he resolves the misdemeanors, until the felony offense is ultimately resolved, he's not. The clock isn't going to start ticking on the extradition matter anyways.
Yeah. You know what? The traffic offenses should probably be transferred to Central, though. Are you able to do that from here? Because I don't want him to have to come down to Hollywood.
I think, Your Honor, my understanding is that if someone's being held, the clerk's office will automatically.
They'll automatically transfer him? All right, good. All right. So I wish you the best of luck. I hope things work out. I really can't do anything on your bonds today because of this parole hold. But you'll see the felony judge soon, and the traffic warrants will go to another judge here. Okay?
Thank you, Judge.
All right, good luck to you.
Thank you.
Marquez Lumpkins. All right. Good morning, sir. You're charged with 1 count of sale of cocaine. There's been a felony warrant that was signed by Judge Schiff. He set a $50,000 bond. I'll find probable cause on the offense. Let me hear to the state about the bond.
One moment, Judge. As far as his history, I'm showing possession of cannabis this year. He went through drug court for possession of alprazolam in 2016. Trespass 2017, cannabis 2015, trespass 2016. Your Honor, I'm not making any requests with respect to the bond that Judge Schiff said. Obviously, I certainly understand if the court takes into consideration any mitigating evidence that the defense may provide.
Okay, all right. Let me hear from the state, I'm sorry, the public defender.
Thank you, Judge. Mr. Lumpkins is going to be requesting from the court a pretrial release option in lieu of bond. He's 23 years of age. At this time, he does not work. He's not in school. He did graduate high school. He is looking for a job. He currently lives with his grandma and his uncle. He does just had a 4-month-old son that he does provide for and cares for. He does receive Social Security benefits due to his father's disability, which is he's deaf. So unfortunately, any family members or Mr. Lumpkins himself will not be able to afford a bond. Would the court consider pretrial release?
Any failures to appear on any of those that you saw?
I'll check, Judge.
All right. I'm inclined to put him on pretrial. It's $20 of, the allegation is $20 of crack. So let me just make sure he doesn't have a long history of non-appearance. I don't think, he probably does not.
Well, okay, his last arrest in 2018 was on a capious failure to appear. Your Honor, I just need one moment.
Yep.
See that? Okay, unfortunately, I can't, Odyssey's down, so I can't see what the basis was, but I do see in 2016, for the possession of alprazolam case I mentioned, he was on pretrial. He got picked up because his judge signed a warrant for violating pretrial.
All right. Yeah, take a peek.
In addition to that, that's all I see in reference to what you were inquiring about, Judge.
And Judge, if I can inquire, was the violation of pretrial due to failure to make contact, or was it more because of a possible dirty urine?
He picked up a new charge. Pretrial's telling me he picked up another charge.
Thank you.
Oy vey. And then there was the you said there was a 2018 capious?
Yes, on a misdemeanor offense.
Let's do this. So how have you been doing? If I want you to interview him, maybe I want to know a little bit more. Have you put him on recall, or you just interview him first?
You can either do it like a pending verification or we have to verify the information.
He'll wind up staying in over the weekend if I do that.
Typically, I have, because it's my pending verification, I have to work that.
Remind me is there any middle ground between a monitor and just standard pretrial?
No.
But I can put him on a curfew, right?
Yes, you can give them a GPS with the curfew or a standard with the curfew.
I don't think he needs a GPS. I don't think he needs a GPS. Mr. Lumpkins, are you employed?
No, sir. I was in the process of trying to find a job because I have a 4-month-old son and have another baby on the way. So I'm trying to live my life right.
Okay. All right. I'll do this. I'll release you to pretrial. I honestly don't think that you need a monitor. I don't think you're going to abscond. Again, the allegation is $20 sale of crack. It's not like he was moving allegedly a large amount. What I will do though is place you on a curfew. So let's do this. For now, we'll make it 7 to 7. So from you can be out of the house from 7 a.m. to 7 p.m. And then after that, after 7 p.m., you'll be at home. Pre-trial, that'll be workable. You can alter that based on his work schedule. So if he gets a night job or something like that, it's fine to alter that. But let's do that. So we'll do pre-trial release, 7 to 7, curfew. Okay? All right, sir. Good luck to you. Hope everything works out. All right, take care. Brendan Clements.
Approaching.
Great. All right, hi there, sir. How are you? You're charged with grand theft and resisting an officer without violence. Any priors and serious failures to appear, anything like that?
I'm showing, I believe, I have to confirm, but he has a pending felony.
He's got a pending felony?
Yes, I'm showing he has a pending attempted strong arm robbery. 2017 felony theft, 22 months state prison. 2016, 2 counts of grand theft, VOP, 22 months. 2016 grand theft, VOP, 22 months. 2015, 2 more grand thefts, both violated probation. He received the same sentence, concurrent. 2012, a grand theft firearm, 5 grand thefts. On all of the cases, he was sentenced to 31.5 months state prison as a habitual offender. Aggravated fleeing and eluding 2012, VOP, 31.5 months. Grand theft 2011, VOP, 31.5 months.
He's not on pretrial right now on the other offense, is he? He's out on bond?
Pretrial will probably be better able to answer that than me. Let me just check something.
Look, here's what I'll do. I'm not gonna jack up your bond on this grand theft as a nonviolent offense. I'll leave it at $1,000. I can't guarantee to you, though, if your other judge is gonna revoke your release conditions. I don't know what they're gonna do.
Thank you, Judge.
All right, good luck to you.
Bye-bye.
All right. Lorraine Kemp.
Approaching.
All right. Hi there, Mr. Kemp. You're charged with possession of cocaine, resisting an officer without violence, and trespassing. I'll find probable cause for the offenses. Priors, Mr. Linder?
Possession of substituted cathinones, 2018, violated probation. 2018, possession of cocaine, violated probation. 2018, possession of cocaine, violated probation. Grand Theft Auto, 2016, VOP, 21 months state prison. Burglary conveyance, 2016, 20 months state prison, habitual offender. Possession of, I'm just going to call it a controlled substance, felony level, 2015, 20 months state prison. Your Honor, it just keeps going on from there, but those are the most recent.
I want to make sure he gets back to court. It's a nonviolent offense. I'll put him on standard pretrial. So, sir, you got to show up Monday morning at the pretrial office in Fort Lauderdale. They'll give you the information. They're going to assure that you get back to court.
Your Honor, I would request random testing.
Yeah, that's good. As a condition, they're going to randomly test your urine for drugs, so you can't have any alcohol, intoxicants, no illicit substances, anything like that. Okay. Random testing. Okay. All right. Good luck to you, sir.
Judge, Mr. Kemp wanted me to let you know, thank you, first of all, and just to let you know, he's going to be admitting himself to treatment once he's released.
That's great. That's great. All right. Good luck to you. God bless you. Okay. Good luck.
Thank you, sir.
All right. Alexander Orengo.
Medical loan.
Okay. Horace Daniels.
Approaching.
He's got a status already coming up on
Yeah,
this.
Your Honor, if I may.
Please.
First off, this is a technicality. When he was first arrested, as I'm sure the court is familiar from back in the day, the data entry, there is no Florida statute per se for attempted murder.
Right.
So when they do the data entry, they had to put in murder.
Right.
I can tell you as an officer of the court, Judge Powell at his first appearance made a finding of proof evident or presumption great and specifically wrote in attempted murder on the findings. So when we filed it as attempted murder, the computer doesn't understand the technical change. It just treats it as a change of charge.
Right.
Since
And
he's being held no bond pursuant to the bond schedule, he has to come back. So what I'd be requesting the court to do is if you could, that the court adopt Judge Powell's previous finding of proof evident or presumption great, not to actually even make a new finding, and that he be held no bond. I believe, and Corey, I don't know if your client can advise, I believe he was arraigned yesterday on this.
That is accurate.
And frankly, unless Mr. Daniels advises Mr. Hill something different, I don't even think he needs to have the status. Your Honor, what happens is there's an administrative order that says all capiases have to be set for a status the next day before the judge.
Right.
I believe, and I've talked to Judge Siegel about this, the intent was for defendants that had capias issues for failure to appear to make sure they don't slip through the cracks. The clerk has taken a very literal interpretation, and anyone that has any kind of capias issued, they set for a status the next day.
Right.
This is not what the intent was. Like I just said, he was just arraigned yesterday.
Right, he was just arraigned, yeah, he may not even need it, but yeah, I'm not gonna make any new findings, really, he should not have been brought to first appearance, but I'll just adopt Judge Powell's findings, and really, you're gonna go forward in your regular division with Judge Bober, okay, sir?
Thank you, Judge.
All right, I wish you luck, take care. Anthony Jackson? Oh, okay. Bernard Sewell?
Did you ask her what the bonds originally? Oh, no, I got it. Don't worry about it.
Oh, yes. Oh, yes, I'm sorry, here, let me put the no bond, yeah. Thank you, sorry about that. All right, hi, Mr. Sewell, let's see, it looks like these are ad charges. Count 6, possession of a weapon or ammunition by a Florida delinquent felon, and count 4, wearing a mask while committing a third-degree felony. Find probable cause for those new charges. What's the bond recommendation on these two?
One moment, Your Honor. Yeah, and
Yes or no bond
I'm
hold?
just checking to see, these are a change of charges, so I'm just checking to see what was originally set.
Perfect. Oh, I'm sorry,
Ryan, can I talk to you for a second?
That's from my civil division, I'm sorry, I meant
Talk to you for a
PTR. Sorry.
Here's what's going on with this case. I don't know if you want.
Sorry about that.
You want me to pick up this one and see? That's not a problem. Here's what happened. We filed the carjacking that he was found. This robbery firearm mask was an up file from possession of weapon by convicted felon. If you want to print out the receipt, if you just want to defer and just let him make a finding for first appearance purposes based on the previous finding of, because if there's a harm carjacking, you know the same elements of both should be the other. Sure. We can see that you can still read it. No, I know this one, this is a little different.
I get ahead of.
Your Honor, if I may.
Sure.
Also, could you look up what the original bond was on the possession of firearm? Okay, I just spoke to Mr. Reedy, Your Honor. What happened in this matter? On the charge which says wearing a mask while committing third-degree felony, what we actually filed, I'm looking at the information, we upfiled it to robbery of firearm while wearing a mask, which is a punishable by life offense.
Right.
The count 1 originally was an armed carjacking, and that's what we filed, and the first appearance division found proof evident of presumption grade, and he's still being held no bond on that.
Okay.
Without any argument from Mr. Reedy at this time, I would ask, considering that the first charge is armed carjacking, as the court's aware, essentially the same elements, what could be considered a lesser included, would satisfy robbery of firearms. So I would ask the court to rely upon the previous first appearance finding in making a finding proof evident presumption grade on count 2 for first appearance purposes only, obviously, and the defense can seek a Arthur hearing on all no bond PBL charges for a full evidentiary hearing before the assigned judge.
Yes, Judge, in light of the no bond hold on count 1, we'll defer any argument regarding proof evident presumption grade until such time as Mr. Sewell can get in front of his division judge.
Okay. So just for first appearances purposes, I will make on that, it's count 4, I think, wearing a mask while committing a third-degree felony.
And if you might want to write in just, it's actually robbery of the firearm with a mask enhancement. Just so there's no confusion about what you ruled on today.
Yeah, I'm gonna cross out.
And I can also let you know, Judge, I saw it's 2,500. The firearm adjudicated delinquent charge was originally set at 2,500, and it's a technical lateral change of charge. So I'm just requesting that be.
All right, yeah, on that's count 6. I'll keep that bond the same, 2,500, and it'll be a no bond hold at this time on count 4, and you'll have an opportunity to go before your division judge soon for a full hearing about getting a bond. Okay. All right.
Judge, just two matters to
Sure.
clarify. The carjacking count, was that actually filed, or is that a count still, or it's not a count?
Yes, and Mr. Hill, yes, it is, and just for the court's edification, obviously the armed carjacking was taking the victim's motor vehicle at gunpoint. The robbery firearm was the taking the keys and his phone prior to taking the vehicle. So one really follows the other, and if the court found proof evident presumption grade for the armed carjacking, I think for first appearance, it would be a reasonable conclusion that there would be proof evident presumption grade for the robbery firearm. What happens at an Arthur hearing, I don't know.
I guess then, Judge, the only other matter would be, I see on my docket, count 6, add charge possession of a firearm but delinquent.
Right, and that was a change
count
of charge, right,
raised
Mr. Linder?
Yes, it was a change of charge. It's probably a technicality dealing with a subsection.
All right, so
I just want to make sure he's not charged with that same crime twice, right? Because
No.
Possible to. Okay.
And I'm keeping the same bond as it was in the initial before they changed 2,500. All right. All right.
Thank you, Judge.
Good luck, sir. Oh, you're welcome. Good luck. How about Kwok Khan Lee?
Approaching.
All right. All right. Good morning, sir. Let's see. You're charged with possession of cocaine, possession of paraphernalia, disobeying a traffic device, and you have 2 probation violation holds. I'll find probable cause for the new offense. It's a $1,000 bond on the possession of cocaine, no monetary charge on the paraphernalia or the traffic charge, and you're going to be held no bond at this time on the violation charges. You have a hearing coming up, though, with your division judge for the violation of probation, October 28th, 8:30 a.m., and you can address that, okay? Good luck to you, sir.
Thank you.
All right, take care. Jamar Claire.
Approaching, Judge. Thank you.
All right, sure. Good morning, Mr. Claire. Sir, you're being held on a parole violation. That's a no bond hold. I'm not able to touch that at this time, but you will have a hearing set up with the parole board, and they'll make a decision going forward, okay? Good luck to you. Hope everything works out.
And were they on parole?
I don't know. The parole board kind of sets their own dates, their own hearing times, so I'm just not sure at this time. I couldn't give you a certainty. I'm sorry. Good luck. Okay. Matthew McKilvin.
He's here, Judge.
Great. All right. Good morning, sir. You're charged with a burglary of an unoccupied conveyance and petty theft in the 2nd degree. I'll find probable cause for the offenses. Any priors, Mr. Linder?
Yes, Your Honor. Let's see. I think he may have a pending drug paraphernalia.
Misdemeanor?
Yes.
Okay.
Loitering and prowling he pled that out October of this year. Trespass from July 2014, sale delivery of cocaine at a near park. 4 years state prison as a habitual offender. Battery on a law enforcement officer, 2013, 21 and a half months state prison, habitual offender. Possession of cocaine, 2012, another one in 2012, another one in 2010. Burglary of a conveyance in 07, year and a half state prison. Another cocaine in 07, same sentence. Another one in 06, same sentence. Another one in 05, nothing further.
So the address that I've got on here is a D-land address. Do you know, can I ask the public defender, does he have any ties to Broward?
Judge, one moment, please.
Sure.
Yes, Judge, he does have strong ties to the community. He's 32 years of age. He's been here for 27 years. He lives with his father, or did live with his father. At this time, unfortunately, he's homeless. He's not working at this time as well either. He indicated to me, because we're going to ask for standard pretrial because a monetary bond is not going to work and due to his lack of address, either will an electronic monitor. He indicated to me that he was on pretrial, standard pretrial before with no violations while being homeless. So he does believe he is a candidate that could comply with the requirements of standard pretrial.
Your Honor, 18 days ago, Mr. McAvey was arrested for loitering and prowling, where the allegations were an officer watched him going up to windows, car windows, looking into windows. He got confronted and said, "Oh yeah, I was going to break into them, but I changed my mind at the last minute." Now, less than 3 weeks later, he's before the court actually breaking into a vehicle.
All right, so he was revoked last time for picking up a new charge. All right, I'm sorry. I don't think for today you're a good candidate for it. I'll set a $5,000 bond on count 1. There's no monetary charge on count 2. And let's see where you go with the division judge, okay? Good luck, sir. And finally, Lee Ross. All right, I'm not gonna, I won't read this charge aloud, assuming the public defender is okay with that.
And
Yeah.
Your Honor, if I may, this is just a technical change of charge, so I think we can take care of this pretty easily without going into too much detail.
Okay.
I can tell you, Judge, does confinement status show what the bond was originally set at? Oh, it's okay, I've got it right here. Your Honor, bond was originally set at $1,500.
Okay.
I'm just requesting that be set back in place.
It looks like a lateral change to me.
It's just one type of subsection versus another subsection.
So we would not object to that.
All right, I'll keep the bond the same. Everything is going to remain the same, and you're going to see your division judge soon, okay, Mr. Ross?
Yes.
All right, good luck to you. Yes, sir.
Is there any way possible I can sign, get out there, because my sister needs my help?
I understand. I understand. Today, I'm going to keep everything the same, but I don't know if he has an upcoming date. Maybe you could be in touch with his public defender, Mr. Reedy, and see if Oh, okay. So the good news is you're going to see your division judge on October 28th. That's very soon, okay?
Okay.
All right. God bless you. Good luck to you, sir.
God bless you. Thank you.
All right. Any other matters before we close out? I think we're done.
If I can just ask, what time are you going to take the bench for the afternoon docket?
If Judge Powell has been starting at 1 o'clock, is that?
Yes,
so I'll start at 1. Yeah, I'll start at 1.
Thank you.
Fantastic. Great to see you this afternoon. So nice to meet
Thank
you.
you.
All right. Great.
You too.
Great. We'll go off the record.
Judge, just to